My lord, there is no order, my
You
lord.
want to hold, like, what do you want to hold? Gandhi Munda.
Lottery, my lord.
Lottery.
Not-
Lottery
and
for
my lord,
what?
it's a ticket face. It's offline lottery, my lord.
Oh,
My lord, there is a water, my lord, why I am referring, my lord. It's 48, my lord. Kindly for a moment, my lord. Here, my lord, there is discussed, my lord. It's 51, my lord. Property portion, my lord. Your lordship will fine, my lord. Only, my lord, not allowing, my lord. Just you have to want to approach the again, my lord. The annexure C, my lord, that was interfered, my lord. Page 42, my lord.
what is this order? Recent order?
My lord, page 42, my lord. That order was interfered by this order, my lord. Order dated, well, 37, 2025, my lord.
1311. Now, what does the Chief Justice say in this judgment of 37, 2025?
Well, under the circumstances, we deem it appropriate to set aside the order responsible passed by the finance
offline and
and remit the matter
lottery in
before.
various state districts in the state of Assam. Amicus has pointed out that in accordance with the lottery demand, only the state government could organize lottery and that too on certain terms. However, it was found that many states after seeking permission by organizing offline and online. Many a time the permission was granted by the legislature without verifying the person declined conducting it. As given that such lottery was given to some native poor people in Bangladesh. He has been prohibiting with your states of probably however one teacher have the right to allow. However, if it was given to the run of act clarified.
প্রকৃত লগ্নাধিপতি হতে পারে এবং কিছু পরে আর সাবল লাগবে ডিল ডিল কে আছে সাবল আমি ডিটেলস পূর্বে করা যায় দেখছি
Okay, now what happened here? In your case, have you applied?
my lord. He's at serial number 4, my lord.
Huh?
At serial number 4, page 42, my lord.
Where?
Page 42, my lord. That impugn order, my lord. He's at serial number 4, my lord.
So this order has already been set aside.
My lord.
Right? What
Now,
for?
now, my lord, see that repetition, my lord, that
So
was
you
filed.
want another order?
That order was passed by Harley Raj.
Similar order being passed by this court, which the division bench has already passed.
My lord.
You want that?
Yes, my lord.
My lord, page 42, Lordship, you will see, my lord, that last year they approved, my lord,
Huh?
for conducting the lottery for the year 2024. This year they will have to submit again. It's not that, my lord, it's a license that will be given to them for every year.
No.
42,
You see,
Lordship, you will see.
Division
no,
bench order was
whatever
passed
may
on
be.
37.
Now, whatever may be, this order has been put to challenge before the division bench in WPC number 6090 of 2024 or something.
Yes.
Okay. Now, this order having been already set aside by the division,
Lordship.
so the petitioner will have to file an application before
Yes,
them,
my lord.
Yes,
Yes, my lord.
and they will therefore do the need.
Consider it, my lord, as per the, my lord. Para 9 and 10, Lordship, you will see, my
Now,
lord.
we quote this.
Para nine.
The order has already been set aside
Yes.
by paragraph 13 to 18.
No,
19, we quote it.
no, page 49, para 9, Lordship, you will see. What was the modification that was made?
No, understood.
Yes.
Paragraph 13 to 19.
Liberty
of this
was
order. I'll quote it and finish it off.
Let them-
Giving them also the liberty to file an
Yes, yes,
application before whom? Finance Secretary.
Yes, madam.
And it,
Earlier it
and
submitted
look into
before the
the
chief
matter
secretary,
in all
Assam.
aspects of the matter and pass a fresh order within 3 weeks to be counted from the date of production of a copy of the order.
Right.
Now, this is very, when is the Ras festival?
Rashtriya is Harley Raj. Harley Raj is yet to come. Harley Raj is not yet over, madam. Is yet to come. Yet to be held.
So 3 weeks will help you
Probably.
because the Diwali thing you cannot.
Well, next,
Because Diwali is coming,
Ras yes, no?
just
Ras,
right
no?
next.
Raj they will help them.
Yes.
Next Raj Raj.
So we'll pass the same order to the effect.
But my lord, one thing may I clarify, my lord, this was for the session 2024, for the last year, last. It's
Whatever
not that,
may
my
be.
lord.
Let them apply.
Yes, they will mention, my lord, for
That
what.
is the modification I will make that order passed by the division bench. Heard Mr. S. Fox, the learned counsel appearing on behalf of the petitioner. And Mr. B. Gogoi, the learned additional advocate general who appeared on behalf of the respondent numbers 1 to 5.
Only thing, my lord, he will have to apply FRS for 2025 last, that may be mentioned.
The petitioner herein have challenged an order dated 13/11/2024 passed by the respondent number 3, declining the petitioner's request to be permitted to hold its annually organized lottery during the occasions of Ras, Lakshmi Puja, etc. And further seeking directions that the respondent number 3 to reconsider the prayer of the petitioner for conducting annual lottery to be held at Sri Sri Lakshmi Mandir, Nityananda, Balaji during
Bazar,
Ras,
bazar nahi, my lord.
Lakshmi Puja, etc. This court have duly taken note of the fact that the order dated 13/11/2024 passed by the finance secretary passed by the secretary to the government of Assam Finance Department have already been interfered with by the learned division bench in in 3 petitions being WPC number has been
60.
interfered with by judgment and order dated 37/2025 in WPC number 6090/2024, WPC number 6401/2024, and WPC number 6402/2024. This court further takes note of that the learned division bench, while dealing with the order dated 13/11/2024, passed by the secretary to the government of Assam Finance Department, had also opined in clear and unambiguous terms that the order dated 13/11/2024 suffers from malice in law, taking into account that the same have been decided on the basis of non-existent, on a non-existent ground, that is restraining order passed in the PIL number 29/2024
My,
by completely disregarding overlooking the leave granted by the division bench in another petition. It is therefore the opinion of this court that as the order dated 13/11/2024 passed by the secretary to the government of Assam Finance Department have already been interfered with. Nothing further is required in the instant proceeding. Be that as it may, this court for the purpose finds it pertinent to quote paragraph number 13 to 18, 19 of the said order judgment, which would enable this court to pass appropriate directions also in the present petition. The said directions are quoted here, the said paragraphs are quoted here in below. Here, you see, this order was passed on 30/7/2025. Thereby directing, why does he have to file another application? He has already filed an application. The same order will follow.
But then the PIL is fixed for.
No, this is not
More-
nothing to PIL with this. There is a specific direction by the division bench.
Well-
Taking into account the above, this court therefore, in view of the above directions passed by the learned division bench of this court, dated in the judgment on order dated 30/7/2025, it is the opinion of this court that the petitioner is also entitled to the similar relief. Accordingly, this court therefore disposes of the instant with petition, thereby setting aside the order dated 13/11/2024 passed by the secretary to the government of Assam Finance Department insofar as the same relates to the petitioner in the instant case, and direct the secretary to the government of Assam Finance Department to again look into all aspects of the matter and pass a fresh order within a period of 3 weeks to be counted from the date of service of a certified copy of this
Right.
order before the secretary to the government of Assam Finance Department. The repetition accordingly stands.
my, I'm obliged.
Item 4.
What is this? Non-payment.
Yes, Lordship, one
Hello.
the bill, Your Lordship.
It is dated on 5th of January. Affidavit to be filed by on or before 15th of December. Mr. G. Bokial appears for. I said yes. It will अपनी ही non-payment. 5/1/2026.
May it please your lordship.
Yes, what is this? Mr.
My lord, here virtually the competitive character of the tender has been done away with. Because initially, if your lordship would kindly come to page number 29, my lord. First come to page 21.
Yes.
Now, please come to somewhere in the middle item category. 52-inch RS ply shuttle steel loom with 6 posts made of metal steel. So this is the item, my lord, which is sought to be procured by the Handloom and Textile Department. Then my lord will kindly come to page 23 towards the bottom. The experience criteria is indicated, my lord. It's a default clause in the tender. In respect of filter applied for experience criteria, bidder or its OEM of the product offered in the bid should have regularly manufactured and supplied the same.
Hello,
Option.
Mr. Chaudhary, Handloom and Textile is this Ardhar or something.
Ah,
He's there. Have you served him a copy?
Government of December.
we have given to government advocate. my lord.
No. They have a standing counsel.
Okay. Then would your lordships kindly take up the matter up 2 o'clock?
Okay,
We'll serve a
Mr.
copy, my lord.
Serve a copy of this.
Yes,
to
yes, yes.
Ardhar.
The copies are here.
When is the last date?
It was initially 14th yesterday, but it is extended till 18th July.
Mr. Chaudhary, can we have it tomorrow? List the matter tomorrow, taking into account that there has been no service of notice upon Mr. Ardhor, who is the standing counsel of the Handloom and Textile Department of the Government of Assam. So the motion, the matter be listed at the motion stage, showing, indicating the name of Mr. Ardhor, SC, Handloom and Textile.
Deplorable.
Rightly, Lordship.
What is this?
Lordship, non-payment of
You
contract.
are a petty contractor, you want 29 lakhs, 30 lakhs?
Yes, Lordship.
How can you be a petty contractor? Huh? The first line out there is wrong.
But with us,
Yes, what is this? Non-payment.
yes, Lordship.
When was this due?
Lordship, this is under S.
একটু নাম কিটা কোন কোন আছে? Finance নাম টাম কোন আছে? PWD, finance, PWD and finance you are accepting?
Yes. What?
To Mr. Doctor accepts motions for revenue. Huh?
Except two, I will please to us one, seven, except. Two, I am appealing.
No. Five, I think is disaster issue to it. This is, comes under the revenue department. Two and five, Doctor al Baki Gita, this is returnable on ninth of January 2026. Affidavit be filed on or before 19th of December 2025.
Published, Lordship.
Yes, what is this item number 7? Somebody came and mentioned it. Who is Mr. A. Ali? Where is item number 8?
Item number 8, I am appearing, madam.
What is your name?
TK Bhuya, my lord.
Item number 7 and 8 are both
My lord,
A. Ali.
Ali, my lord, he said that he requested me to appear before lordship, my lord, said that his son has some problems, my lord. He is
Then
coming, my
seven?
lord. 7 is.
Some lady came over to mention
Yes.
it. And she happened to be a lady, she was the counsel who was representing in item
Yes,
number
my lord.
8.
I will inform him. I will inform her, my lord.
What?
That she is there in court number 21, my lord. This lady, my lord.
No, but she said that she wants to withdraw
Withdraw,
this.
my lord. Yes, my lord.
I want to withdraw this.
In item 7,
But,
my lord, I
but
am not-
where is Miss M. Khatun? What is this matter? Let me dismiss it. What is this case? Who is appearing for the fishery?
I'm looking for 2, 3 and 4.
7, no?
There is one petition of what prayer is being made.
Not to reject the tender, not to reject.
Yes.
What is
Lordship.
the number of that case?
The WBC 5827 of 2025.
Also need to order to ano.
Order was on 27.
26.
Order was passed on 26.
Order number?
5827 of 25. On 26, my lord, I submitted an application before the authority, my lord, annexure 6, my lord, page 60.
So
Yeah.
now today I should dismiss it.
Madam-
Exactly, I have done it. Now what is this? Why have you filed this?
My lord, after filing of my application and for correction of the omission, my lord, to accept my MSME certificate, then my lord, one message was sent to my mobile, my lord. Your lordship may kindly see at page 66, my lord.
Wait,
Page 66, annexure 7A, my lord. Sixty-six. There is your bid IDs so and so against the tender ID so and so has been open and your bid has been admitted by the duly constituted committee.
this was of 6th of September,
6th of September, my lord.
but this was, you filed a writ petition subsequently.
Not
Yes, yes.
not
The
subse-
last writ petition was filed.
not subsequently, my lord. Before that, I submitted and it was not listed.
No, Mr. You filed this writ petition subsequently. This 5827 of 2025. Obviously, you filed this subsequently.
My lord,
That is why you came up before this court.
My lord, on. No, my lord, on. We submitted it on 26/9, my lord.
Huh?
We filed,
I even directed here. I
We-
remember.
my
What
lord,
order I passed.
we filed our.
President
petition-
above, this is the court is of the opinion that this is not a fit case for issuance of any interim direction staying the tender.
Yes,
I
yes.
directed to bring on record the stand, taking into account that the contract pertains to supply of dietary articles and there is an urgent need. Respondents are at liberty to go ahead with the settlement of the said tender process. Then what? This was moved on 26th of
26 of 9.
September. As on that date, you had this message.
No.
You had this message as on 26th of September,
My lord,
100%. You have not raised it. Then why
My
on
lord,
earth
my lord.
you are not bound under order 2?
my lord, subsequently it was on 7th October, my lord, it was
Where is the 7th October?
annexure 8, my lord, page 68, my lord.
Page?
Page 68, my lord.
This is of 28th of September.
7th of October, my lord.
Where is your page 58?
68, my lord, 68.
Okay, 7th of October. Okay, then
It is hereby informed that due to certain administrative reasons, the previously published technical evaluation report in connection with tender ID so and so, in respect of zone 1, 2, 4, and 5 respectively are hereby cancelled. A revised technical evaluation report is being issued separately.
it is okay. So
It
what
is
is wrong?
On 7th, my lord, the earlier technical evaluation report which was challenged in that petition, your lordship may kindly see annexure 5.
The same thing you are challenging again. Same thing.
Not the same, my lord.
No, no, for your business is the same. Kindly come to number 8, page 59.
Yes, my lord.
Yes.
Yes,
Page 59,
here-
number 8
Here,
is exactly the same. Now what has happened is,
no, no, my
is
lord.
no, Mr. Chaudhary, you have to understand. The technical evaluation report dated 28th of September 2025 had rejected you on the ground of two grounds. That you did not have that annual turnover of only 5 crores submitted and MSME registration certificate is required, which is not submitted.
My lord, subsequently, my lord.
No,
I-
Mr. Chaudhary, can you listen to this?
Yes, yes.
There were 8 bidders who were found to be technically responsive in the September 2025. Now in the second one, that is on 7th of October 2025, out of 8, 6 are there. Your reason for disqualification remains the same.
Not say, my lord, I am showing, my lord. There another ground they have shown. Annual turnover 5 crore is submitted for which MSME regulation certificate is required and the registration certificate is not submitted.
Hmm.
Two geotech jail photos are missing in online document, but in hard copies, these were there, my lord.
Let us not,
Sir, it is-
for that
my lord,
again.
My
has
my
no
lord,
matter.
only my lord, my submission, my lord.
Okay, this, we make it further beyond that. You go ahead again. There's a further direction that you go ahead.
My lord,
You pass a similar order. No, nothing doing.
Your lordship may kindly see the clause 228, my lord.
For what? Geotech?
Not geotech, my lord. Regarding deviation, my lord. It is a omission, my lord, that may be corrected, my lord. As per the clause itself, my lord.
Nothing
Your
doing.
lordship may kindly see, my lord, at page 30, my lord.
So we
Twen-
dismiss this. Okay.
My lord, it may be corrected, my lord. The
No.
authorities has accepted, my lord, my application for MSME certificate, my lord. And after to make
No,
favor
nothing doing.
to make favor to the respondent number 3, so he survives alone, my lord, here in
Please
the
give
beat, my lord.
us. You remember this case? Unlisted moved out there. So then he had challenged this thing, the technical bit. And the same is now again another one.
Because the earlier one has
We
become
do one
infraction.
thing. We fix this on 1711 together. In the meantime, go ahead, settle the tender.
Only one respond number survives only, my lord, if might be this.
Nothing doing, nothing doing. Should notice. Should I dismiss it?
My lord, the-
Should I dismiss it? No, no. One thing
my
is
lord,
there.
only, my lord, my submission would be, my lord.
Your submission is already there. The reason what you are challenging, Mr. Chaudhary, earlier also you were disqualified. Now also you remain to be disqualified.
That is correct, my lord. But
So if
but-
that be so, the question
Only-
does not, anything changes.
Lordship may kindly consider the paragraph page 29 and 2030, my lord. Yeah,
This is the second round. We dismiss it with cost. How much? 25,000.
Let it come on the
On
same.
environmental degradation of page 396. How many copies have been made? So we have to do it per page, 5,000 rupees.
Already there was a 4 copies.
Huh?
Already 4 copies, 1 copy
Four
for us.
copies, no. It's too much. Right time. Dismiss it with cost, huge cost. Therefore, I think dismiss it. On the ground of again trying to re-agitate the matter after not getting a certain interim order.
No, my lord. that
On
is-
this ground
that is-
only.
That
we
is not the
dismiss.
correct, my
No,
lord.
no, we dismiss it with cost of 25,000.
My lord,
On this ground, better division bench may help you out.
my lord,
May get this.
let it come on 17.
No,
my lord.
no, this
Along-
might
along
be
with-
dismissing with
on-
cost
on that-
of
On that day,
25,000.
your lordship will consider.
On the ground that you are again trying to pray for an interim order after having got a rejection on 26.
My lord, that has become infractions, my lord, after cancellation, my lord, on 7th, my lord.
Where?
That expedition has become infractions, my lord. Annexer 6, my lord. Annex. No, no, sir.
Where is it cancelled?
Annexer
The earlier
7, my
one?
lord. Yes,
Where is it cancelled? The earlier one?
cancellation annexer 8, my lord.
Huh?
Page number 68, my lord.
We administered the previously published so are hereby cancelled. Okay.
Cancel, my lord. That
Okay,
become
level.
infractions.
Issue notice making it returnable on 17/11/2025. Mr. K. Gogoi accepts notice on behalf of respondent numbers 1, 2, 1 and 2. Extra copies of the writ petition be furnished to him within 2 days. As regards the respondent numbers 3, 4 and 5, who are those?
Only 3, my lord.
respondent number 3,
Yes, my lord.
steps be taken by way of registered as well as usual. In addition to that, the petitioner is also given the liberty to take steps by way of dusty routed to the registry of this court and file an affidavit of service on or before the next date. Full stop. Full stop. The present writ petition is the second round of litigation filed by the petitioner on the ground that the earlier writ petition so filed, being WPC number 5827 of 2025, whereby the technical evaluation report dated 29/2025 was put to challenge, have already been cancelled, and by way of an additional corrigendum dated 7/10/2025 and another technical evaluation report dated 7/10/2025 have been made, whereby the petitioner have been again held to be technically not responsive. So, sir, Mr. D. Chaudhary, the learned counsel appearing on behalf of the petitioner, therefore submitted that the earlier writ petition being WPC number 5827 of 2025 had become infructuous. So, sir, next. The case of the petitioner herein is that in terms with the additional terms and conditions of the tender document dated 6/8/2025 and more particularly clause 4, the bidders were required to submit the minimum average annual turnover for the last 3 years, which should not be below 11 crores. Pursuant to a proceedings being WPC number 4660 of 2025, an additional corrigendum was issued on 26/8/2025, whereby in respect to micro, small and medium enterprises, the minimum average annual turnover for the last 3 years, as mentioned in clause 4 of the additional terms and conditions, was reduced to rupees 5 crores. The petitioner was one of the bidders, and his average annual turnover for the last 3 years were less than rupees 11 crores. The case of the petitioner is that the petitioner is the micro enterprise,
Yes, sir. MSME
and as such, the technical bid could not have been rejected on the ground that the petitioner did not have 11 crores as average financial turnover for the last 3 years. This court further duly takes note of the technical evaluation report dated 7/10/2025, wherein it has been categorically mentioned the reasons for which the petitioner's bid was rejected. The reasons so cited were that the annual turnover of 5 crores was submitted, for which MSME registration certificate is required, and the registration certificate was not submitted. Additionally, it was also mentioned that 2 geotech jail photos are missing in the online document. Full stop. The ground of rejection. Full stop. It is an admitted fact that the petitioner did not submit the MSME registration certificate at the time of submission of the document. Subsequently, the petitioner wanted to submit, isn't it?
Yes, we have submitted already, my lord.
The
That
petitioner had submitted,
by-
which have not been taken into consideration. Also, considering the above, that the petitioner did not submit the additional, the MSME registration certificate, which was required to be submitted at the time of submission of the bid to take the benefit of having less than average 11 crore turnover. Comma. It is the opinion of this court that the petitioner is not entitled to any interim directions. The respondents, however, are directed to bring on record their stand by filing their affidavit on or before the next date. Mr. K. Gogoi, the learned counsel appearing on behalf of the petition respondents, number 1 and 2, duly submits that the contract pertains to supply of dietary articles and there is an urgent need. It is made clear that the pendency of the instant writ petition shall not bar the respondent authority to proceed with the tender process.
Much.
60.
Yes, what is this?
The petitioner is a contractors association, Your Lordship. They are challenging hearing the shifting of the divisional office from Kabuganj to Palonghat. Now, Your Lordship, this shifting, this is not in pursuance of a administrative decision, but due to political interference, Your Lordship. Only on the basis of a letter,
What are you asking for? Who are you?
I am contractor association, Your Lordship.
And what is your problem? When they shift the office of the executive engineer, Dhonai Solai division, irrigation Dholai from the office complex at Kabuganj.
Kabuganj to Palonghat, Your Lordship.
Why?
On the division has been newly created, Your Lordship, in 2021. An office has already been set up at Kabuganj at considerable expense. Now, without any reason, only on the basis of a letter issued by the local MLA, they have taken the decision to shift only the executive engineer. Even the chief engineer was also not aware. So we had filed a complaint before the chief engineer. Now, due to, as he had not taken, the executive engineer had not taken the administrative approval of the higher authorities, now it is hanging, Your Lordship.
Huh?
The matter is now hanging.
So
And
you want to expedite it?
no, Your Lordship.
Then why are you filing this type of writ petition?
Because chief engineer also, there is political pressure to shift. Your Lordship, I'll place the documents. What has happened? The
But you see, the government has too much of money.
Lordship.
They can spend the public money by having one office here, one office there.
Yes, sir.
They can do so.
Yes, sir.
Why should this court interfere?
Your Lordship, this is not due to the government's decision, Your Lordship. Not due to the government's decision. Due to
Unless the government has taken a decision.
no,
our decision
not
structures
taken, Your Lordship. I'll place only the executive engineer.
premature.
Only the executive engineer, they have taken the decision to shift. Executive engineer along with
Executive
the,
engineer has no power to shift.
yes, Your Lordship, no power to shift, but he has taken the decision. It's on record, Your Lordship.
He,
Only-
what?
Yes,
me
Your Lordship. Page 57, Your Lordship, letter of the MLA, Honorable MLA.
Request for sparing of vacant RCC
Yes,
building
Your
at so for establishment of the divisional office of the
executive
executive engineer.
engineer.
Like to draw your kind attention to the fact that the vacant RCC building under directorate of and women are utilized by the. If you oblige as you. MLA Dholai.
This is directly addressed to the
Director of
veterinary department, Your Lordship, not even to the executive engineer. Now, the executive engineer,
Vacant building and. With 2 year by joint direct.
page 61, the decision is conveyed, Your Lordship.
My case has no locus. Absolutely no locus.
In case of arbitrary action and
What arbitrary action?
arbitrary, your lordship, they have not even taken the approval of the higher authorities. That is
No,
clearly stated.
understood, they will take, let them take.
Okay.
Let them take,
They have not taken a decision.
let them take.
Yes, your lord.
After that, if you are aggrieved, let us see. Why are you aggrieved?
I am agree because, your lordship, the office, if it is shifted there, it's in a remote locality, your lordship. And it is not easily accessible. There is no private transport also there available. The public transport is not available. By way of private transport, we have to go. Now,
Who?
the contractors and the local farmers, your lordship.
Who?
Lordship, I am the contractor working there in that office and the local,
You are a class one contractor.
lordship,
You are a contractors association.
contractors association. All the contractors are here.
So,
Your lordship, now, because of this,
Hmm.
it will become very difficult, your lordship, on the part of the public to go to that office. And your lordship, already there is a office set up. Now, only at the instance of a letter by the local MLA, they have taken this decision without convening even the chief engineer. We have filed a complaint before the chief engineer. He has issued a notice to the executive engineer.
Hmm.
Now, the executive engineer has submitted a report saying that this is a damp building, so we cannot shift there. But it is not a fact, your lordship.
we cannot,
It is a damp building, so we cannot shift here. The Assam type house is damp. Floor of the Assam type house is
of Dholai.
at that Kabuganj, newly built. Kabuganj, where it is built, the Dhalai office. Now, it is completely wrong, your lordship, factually wrong. If the Honorable Deputy Commissioner inspects it, matter will be clear, your lordship. And we have already, he has also stated that no higher authority approval was taken before taking this decision. At page 61, he had already taken the decision. The
Lordship, Lordship, the plan has to be, Lordship, come from the higher authority only, Lordship, without.
No,
the-
they have started
without
work
the-
also. They have started work. I have stated, your lordship. They have already cleaned the building and painted without any approval from the higher authority, your lordship. Page 61, he has stated to the joint director that the executive engineer, I have the honor to inform you that undersigned along with assistant executive engineer Dhulai and other officials of the DZ visited the aforesaid building at Palonghat on 25/8/2025 and decided to shift the division office after cleaning the premises and internal painting of the building. Already they have cleaned as per my instruction, and also painting is going on in the internal part. Actually, at page 67, 66, 67, the local farmers have filed a complaint.
When was this Kabuganj division headquarter of the year was fixed at Kabugan? When was this set up?
Set up, your lordship, 2023-24 works were going on. I have annexed the audit,
And what were you doing prior to that?
lordship.
Prior to that, what were you?
Now the office, presently it is also in Silchar.
No, what were you doing prior to that? Prior
Prior-
to 2023-24? Because it became only
No, no.
recently.
It is at Kabuganj, new,
Kabuganj when?
this new Palonghat. Now they are shifting to
Now, how
Palonghat.
they want to shift?
To Palonghat. Kabuganj, we are,
Could not be shifted to owing to these region division office could not be shifted to Kabuganj.
lordship,
So now they want to shift it to where?
Palonghat. Another 4.5 kilometers ahead. The office was approved at
Palonghat,
Kabuganj.
at Palonghat. So, office, but was the office set up?
At Kabuganj, set up, your lordship. I have annexed it.
They, in this RTI in application, they say there are problems.
Lordship,
You give an undertaking
lordship.
that you are going to make that office properly free of cost. Give an undertaking that you make that office free of cost, they will have it. What do you say?
Lordship,
Mr. Upadhyay, what do you say? Let them have a construction,
yes.
let them give an undertaking, then only I'll issue notice, not prior to that. Let them give an undertaking that they are going to make a proper office out there free of cost
By their own.
by their own. Then they will,
Lordship,
on the basis of that,
I'll have to take instruction from them. Lordship, on that. Lordship, may
because
kindly-
then you can
Lordship,
see. I'll
because-
put it out there that you give an undertaking.
Lordship,
I'll
I also take the instruction.
Huh? देखो how much time? 1 week?
Lordship.
The instant writ petition has been filed by the Contractors Association, Irrigation, Kachar, Karimganj Circle, by an association in the name and style of Contractors Association, Irrigation, Kachar, Karimganj Circle, whereby they have challenged the decision to shift the headquarters of
The divisional office.
the, the headquarters of the division of the Dholai Sonai Division Irrigation from Kabuganj to Palonghat. Gusto. This court duly takes note of an information provided by the executive engineer Dholai Sonai Division Irrigation dated 22/9/2025, wherein it has been mentioned that even after spending 35 lakhs on the building, on the Assam type building, the division office could not be shifted to Kabuganj, as the building has been pursuant to the monsoon rains have become unhygienic, and presently the building, Assam type building, is being used as a store section. Muslim. This court inquired with the learned counsel appearing on behalf of the petitioner as to whether the Contractors Association, Karimganj, the petitioner association, was ready to make the Assam type building to make necessary constructions in the Assam type building at Kabuganj at their own cost, so that the said Assam type building can be used as the divisional office. Mr. So-and-so appearing on behalf of the petitioner submits that he would obtain instructions. Mr. N.N. Upadhyay, the learned counsel appearing on behalf of the irrigation department, also submits that he would provide an estimate, a cost which would be required for the purpose of reconstruction of the Assam type building to be made usable. First, list this matter on 29th of October 2025. We'll have it on 24th of October 2025. 25th is Saturday.
Saturday.
Then 27 possible.
Okay, 27. You get the answer. You will withdraw.
Lordship, in the meantime, they may not proceed, your lordship.
What?
In the meantime, they,
Absolutely no. Give an undertaking today. Then I'll pass an order.
For admission item
only your lordship, that may
9
be
to
reflected
13.
on in next date. The interim prayer may be considered, that may be reflected
What interim prayer?
by regarding the status quo, your lordship.
Mr. Counsel, I am yet to issue notice.
Lordship,
Notice has not
The
been
next-
issued. Forget about interim.
yes, sir.
Come up for motion only.
For admission item 9 to 13.
Yes, what has happened?
Yes, Lordship, we had a discussion.
There has been a meeting, madam. So now the department is calculating the actual amount that has to be paid, madam. Pursuant to that, department is taking another meeting within next 2 weeks, madam, to finalize the terms.
When?
No, Lordship, actually, that terms has more or less been finalized. They have offered to pay us as per the MSME Act up to 2019.
Very good.
And thereafter, at the rate of 12% simple interest, we have agreed to that.
Whatever may be,
I have been.
come to a negotiated settlement. They
One-
should ask only till 2019 only. That was what has been mentioned by Mr. M. Hazarika earlier. Till 2019 only. Remaining, whatever may be.
They have to negotiate the 12%.
Now, the department is simply calculating how much exactly they have to pay. After that.
They'll make the payment. Hopefully.
Are you calculating with your fingertips or calculator?
Calculating, madam.
With the fingertips or calculator? Does it take such a long time? It has been quite a time. How do I on earth during on a day when AI generated everything is going on and give you time for calculate? Tell me, would it look nice in the order that for the purpose of calculation it takes?
One more meeting has been sought, madam, in next 2 weeks, my lord, we will fix a date. Then, hopefully, my lord.
Lordship, let the entire exercise be cleared within a month, including payment from today.
Huh?
Let the entire exercise be cleared within a month, including payment.
See with that, let them, let me close it out first time. Let them come up with the figure. Okay, Mr. I. Bhattakur submits that there has been some negotiated settlement arrived at, and on the basis of which the PHA department is making the necessary is taking appropriate steps. First of all, he therefore seeks that a week's time may be granted for the purpose of providing the details as to how much amount the PHE department would be paying to the petitioner in the 3 writ petitions. First, list this matter on 30/10/2025
Obliged.
at the top of the list.
Item 14.
May this lordship, my lord, I need some time, 2 weeks' time to
what?
communicate with my
What is this matter about?
lord.
Lordship, here the chief engineer irrigation has filed an affidavit, Lordship, in
Non-payment.
June, Lordship. In fact, Lordship, as per the affidavit, entire amount has been paid. In fact, Lordship, we owe from the petitioner some amount. Lordship. So The paragraph C of the affidavit filed by the chief engineer says, Lordship, he is nothing to receive, Lordship, not to.
Where is your statement
Page
that state that a
48,
matter
paragraph
of payment
C.
against the work implemented by the is now under the government? With the government in the irrigation approval on the matter is awaited. On receipt of the abnormality sanction, the necessary arrangement will be made as required.
No, no.
Then this is some
Page
affidavit filed by
48, page
response number
48,
two.
Lordship, additional affidavit is filed, Lord.
Then after that, did you make payment?
In fact, Lordship, after verification, Lordship, it comes to the knowledge of the authorities, Lordship. That page
We are
48,
one
Lordship,
paid out.
comes, Lordship.
But the total recoverable amount from the petitioner against the scheme stands at rupees 6.24 lakh. 62 lakh. In spite of the petitioner is yet to deposit the amount of the record will be paid. Madam, why you are not going before the civil court? Unnecessary filing all these things.
My lord, I couldn't communicate with the client, with the petitioner. I pray for 2 weeks' time since
For what?
to take instruction, my lord, for the instruction.
For what?
Lord, as my senior has been elevated to the bench, I am unable to handle this.
After a decade has passed for this matter on going on, now we ask for 2 weeks time from a court
lord-
of this nature?
My lord, just 2 weeks' time, Lord, to communicate with the client. my
No,
lord.
no, no,
Petitioner.
2 weeks, nay, I will give you time till 2 o'clock. 2
No,
o'clock,
I-
obtain your
I don't have,
instructions. Only order I can pass is to go to the civil court. You see, you have claimed an amount of certain amounts.
my lord,
They say that not only that, they are entitled to 62 lakhs. Now the question is whether you are entitled to any amount or not, or they are entitled to any amount. This is to be fought. The thing has to be fought out of before the civil court, not here.
I need some, I don't have a contact number of the petitioner also.
Don't have
Maybe-
it.
maybe-
Very good.
Maybe a week time, my lord.
Are you a counsel who is appearing for anybody out here of the petitioner? And you say that you don't have the contact number of the
My lord,
petitioner.
I have not handled this client, my lord. That's the reason.
What?
I haven't handled this petition, this petitioner.
What's your senior?
My lord, my senior has been elevated to bench. R. Mazumdar.
R.
my
Mujumdar.
lord.
Who is he?
He has been elevated to the bench, my lord.
So,
I pray that like a week time so that I can
Then-
communicate with the petitioner.
Lordship, she has paid number of occasions for filing reply.
no. There is one, Mr. P.N. Goswami is there. I. Kolita is there. All these people are there. No case. Rights dismissed. No. I think this is the only order you can get. 2 o'clock is the maximum time I can give you. 2 weeks is for 2 o'clock. 2 o'clock.
Therefore, could not be done. Then the petitioner raised the issue that how can the next door neighbor be settled, your lordship. Then they issued a notice of eviction to the petitioner. This eviction notice was stayed by this honorable. Then they came before this honorable saying that there is no record before the regarding all this, your lordship. Then this court has passed the order on 18/8/24.
You are appearing for whom? Student Talukdar, Prafulla?
I am appearing for the second case, that is Prafulla Datta. Suren Talukdar is another matter, but regarding the same land, because here there was a construction made by
Appearing for Student Talukdar. You come this way.
Suren Talukdar basically was with regard to a construction made in my land. That part, your lordship, is not that important, but mainly with regard to Prafulla Datta.
Student Talukdar, what is his case?
His case is that I have constructed a building.
To take necessary action to resist the illegal construction of on government land adjacent to the land of petitioner. Land better respond number 7. Who is respond number 7?
So there was some,
Who is respond number 7?
yes, in that case, yes.
Now,
Suren Talukdars. Now what has happened is
you
court
were
direct.
in Pattaland.
No, we are not in Patta land. The issue was that these were all government land. The government land, we say it is a government land, but they say it is not been demarcated within a government land, forest land, nothing has been demarcated. There's a single Patta 100. So from that,
Patta or Dag?
sorry, Dag 100. And from that Dag, this, my next door neighbor, that Suren Talukdar, was given Patta. I applied for Patta. So that was the issue that I also applied for Patta after he got the Patta. They came and said, we do not have any record. There was no demarcation of any land here and there, so we cannot give you Patta. Then I made an application saying then how you can give Patta to
No,
Suren
no.
Talukdar.
I'll take care of your situation. First, you come with me. You have been given a patta
Yes, your lordship.
and he is making a construction in the government land.
Yes, lordship.
Why are you against it?
Because he's encroaching my property also, your lordship.
So then why you're not filing a civil suit? Yes, Mr. Chaudhary.
My lord,
You have been given a patta.
yes, ma'am.
Now, is he encroaching on your land?
Yes, not
No.
land, my lord.
Because your prayer is,
They-
his construction in government land.
Not in accordance with the norms of the GMC.
But that is a different thing. GMC or what is your prayer? See your prayer at page 11. As to why a writ in the nature of the mandamus should not be issued directing them to take necessary action to resist the illegal construction on government land adjacent to the land of the petitioner and illegal occupation on government land by the respondent and for removal of construction in accordance with law, and to why direction should not be issued to respond for registering a case against the FIR against so and so. What is this? Go before a civil court if he is encroaching upon your land. He is not encroaching upon your land.
My lord,
Government land,
We-
it is for the government to take a call.
the government has my lord, in the affidavit, my lord, they have stated, my lord, the notice has been issued to them for vacating
I'm
the.
not concerned with that. I'm not on that. But first of all, what is your locus?
My lord,
How many cases have you filed against government land?
my lord, my.
He is constructing on government land. How are you gonna-
My purpose was filing of the writ petition, my lord. He is building enclosed upon my land, my lord.
Where is your prayer? The relief does not say so. And if he is constructing or encroaching, it is a case of a civil court. You have a patta land.
Yes,
Then what is the question? Whether he constructs, I'll consider his case next. But first, what is your case? If he is not encroaching upon your land, what is there to fight against him?
my lord, the entire statements made in the writ petition, my lord, regarding the deviation of the norms of the GMC, my lord, regarding that.
Understood. For that, have
And
you
to
moved
that extent, my
against the
lord,
GMC?
I will amend my prayer, my lord.
What amend your prayer for what? In 2017, where 16 matter in 2025, you amend your prayer. That is not your case at all.
My case is, my lord, that their building has enclosed, my lord,
Where is your prayer? Where is your statement? Let me see, okay, your
Statement.
statement that you have encroached. Where is your statement?
at paragraph 4, my lord.
Have you made the GMC a party?
James, yes, ma'am.
GMD is a part.
And where is your responder? Where is your
G-
representation to the
GMD is a party.
Where is your representation to the GMC?
My lord, at annex Page 20, my lord, annex 4, my lord.
This is absolutely a civil dispute. Kindly see your application, page 20 of your petition. I've been residing there with my family by constructing a house. One Prafulla Datta land is situated at the northern side of my land. He has been residing there several years ago, means long time back. He had constructed an RCC building close to my boundary wall. He assured to rectify the same when I obstructed for such construction. Now he has
Yes.
extended the roof of that house over my boundary wall. When I obstructed, he and his son threatened to kill me. Now he has started construction of another RCC besides the Seda.
The post and rod of the house
House has extended
over
over
my
my boundary. Civil case,
My lord,
civil case.
my lord, it is a GMD area, my lord.
No, civil, GMD area, civil.
My
court
lord,
is not
GMD
there.
area, my lord, as per norms, he cannot build a building, my lord, like that, my lord.
That is a different thing, but the question is, where is the question of each person? This is purely whether it is within your boundary or not, how this is to be looked into by the civil court. And Mr. Nayak, what is your, Mr. Nayak,
Already, my lord, affidavit has been.
what is your stand on as regards the?
One affidavit has been filed on behalf of the MDA law. There we have taken the standard for, the land in question lot, it's a government land.
His land,
Here,
not his
No.
land.
Yes.
it's a government.
Procular Datta's land.
Prafulla Datta's is government land.
Yes.
Now you have not given any permission.
There is no question of giving any permission.
Then what are you taking? Action.
But this-
Under
this
86,
was
you have to
issued by
take
the-
action.
We have communicated to the deputy commissioner.
Huh?
We have communicated to the deputy commissioner.
But does the GMD or the GMC has no power to take action if it is without any permission?
Generally, if it is government land lot, we communicate to the deputy commissioner. And
For eviction,
it's question of eviction.
eviction, but I'm not concerned with eviction. I'm concerned about construction being made
But
without
in
permission.
this case, for eviction lot, one notice is already there by the circle office.
That is okay. That is done under Rule 18. From government land, eviction is there, that is Rule 18. That is another aspect. I'm not on that.
Yeah.
But if a construction is made without the permission from the GMC or GMDA, what actions do you take? You don't take any action if it is done in government land.
Yeah, it's 25 losses of the MDA. Any construction without permission, we can take it.
Why haven't you taken action?
Our understanding of the, the officers that if as it is a government land also, let us communicate the same to the deputy commissioner and deputy commissioner will take action.
So we have to now understand that if a person makes a construction without any permission on government land, the GMC or DMDA would not take any action on its own, but the action will be only taken to the deputy commissioner.
That is the procedure we generally follow.
So we take it as it is. That is the, say that is the law for you.
That is the stand taken in the.
You cannot take that stand because the law categorically says that any construction raised without permission is illegal.
Section 25 is quite clear.
And 86 is also very clear.
Yeah, if section 25 is not followed, then section 87.
87, 86, 87 will come in.
87A.
So why you are not taking action? Again, not only GMC also, this is outside GMC area.
Outside GMC. but
No, it
GMC
cannot be. It is in Guwahati 5. Where is that? In Panjabari.
Jonas moved, I think.
Jonas,
Khatgaon is outside GMC.
earlier it was outside GMC. my lord.
Now?
At present, I don't know, my lord, but it is within GMD. my lord.
Yeah. Take
GMC,
it that the government does not take any action. And the GMC, GMDA would not take any action under it. And if any construction has been made in your place, it's for a civil court.
my lord,
Civil court.
my lord, that illegal construction violating the norms of the GMDA, my lord,
So
GMC.
violating the GMDA has no power.
We approached the GMDA.
You see, the GMDA has no power to demolish as per the stand of the GMDA. They will only inform the deputy commissioner. The deputy commissioner
Deputy
will issue a
commissioner
notice for
Has,
eviction.
has issued a notice, my lord.
Also, they have issued the notice, they have not done anything. So that is okay. So your case, go to the civil court. We observe that the GMDA has no power as per their stand. And now let us hear Mr. Manan. You are on government land. Then how did you raise construction?
I was in the government land for the last 44 years.
So
Let me, whatever it is, your lord. Now, question, just one point I would like to mention with regard to that case, that the construction VC said was protruding to his land or whatever, that has been demolished. There was an order by the Honorable Court, interim order, that the construction should be stopped. It was not, and then it was stopped and it was demolished. Therefore, there was an order by the Honorable Court earlier, forgot the date. That order, court said that you verify whether that demolition has been done or not. I don't know whether any GMC has subsequently done it or not. They have not filed any affidavit. I don't know.
Was directed to the deputy commissioner. I think on last day it also be processed pending.
deputy commissioner cannot demolish.
No, some order was given whether this was demolished, because I have taken a stand that it was already demolished or this whatever has been protruded to their part has been demolished. So that was taken a stand. So therefore court wanted, the DC was directed to verify and apprise this court. But they did not file any affidavit subsequent. In this case, your lordship, what has happened? I am the next door neighbor of the other petitioner. Now what has happened? We applied for settlement of the land. He was settled with the land, I was not settled. So what has happened? We specifically made a mention that they made a, then we, after submission, when I was not settled, I approached the authorities. They said that there is no demarcation of the land. Since there was no demarcation of the particular land, your lordship, then how the patta was given to the other person? When I raised this objection, then they issued
No,
this.
no, you are challenging the notice.
That notice is challenged. That is
You are
also
challenging the notice and asking for a direction that the land should be settled with you.
Yes, that is
That's your
what.
prayer.
Yes,
That's only your prayer.
that is
First
my.
is setting. No, there is no other prayer.
No, the prayer is, but when this matter was,
Other things we are not concerned. Kindly come to page 11 of your petition.
yes,
As to a right in the nature should not be issued to set aside and quash the impugn notice. And
Yes.
so cause as to a mandamus should not be issued to direct respondents to settle one
Yes.
katha under the occupation of AR and allow the remain in occupation of the AR and so and so.
yes,
That's all.
that's all. So therefore, your lordship, my second prayer, first prayer, anyway, there was a second
First
prayer
prayer is the most important.
important because that was
Because
stated.
this court is not going to interfere with the first.
Whatever, your lordship, I'm
You are
not on
in
that.
government land.
Lordship may dismiss the matter. That is not what I'm trying to point out. The second prayer, when we raised the second prayer, what they came up and said, that is important. What they came up and said, there was no demarcation of the particular land. That Dag has not been demarcated. When there is no demarcation, how a patta was issued? That was the question raised. When they can be issued the patta, why we could not be issued the patta? Then they said, no, there was no demarcation
But
of the
how
land.
can this court go into and enter into those disputes?
This dispute, this
They
was
have a
direct-
land policy there. They are to.
this
pursue
was
it.
directed by this honorable court.
Uh.
Court, that is why I said your lordship will kindly look into the orders
No,
dated
no, no,
18
no, we are not going to look. at
whatever,
it.
lordship, I am saying, the lordship
You
will
are
do
in
whatever.
government land, you are to be evicted, notice has been issued, you must have submitted your
evict it.
reply, then they will.
See, if
submit-
it is so easy, it's very good, evict everyone. I'm not stopping anybody. But what I'm trying to point out, if that is not looked into, and this court has specifically passed 2-3 orders, where is this judicial order will go? They should come up and say, no, demarcation has not been done or done. That is why, since it is a demarcated, it's a government land, we have issued the notice. You don't even know whether this is a government land or what land, not land, no demarcation, nothing. How you can issue a notice on that? This is what is the question will arise. They have then came up
Now,
saying,
are they saying that this is not a government land?
they are not saying anything. In the affidavit, your lordship will say, they say it's a government land, but there is no demarcation between government land, forest land, any other land. Their affidavit says so.
In my affidavit, it is dated 20 March 2017.
Now, Mr. Naik,
Lordship,
we'll hear you, you are appearing for the GMDA. Let him appear.
Lordship will see
What
their.
is your stand as regards the land where the petitioner in WPC number 7852 is there.
Actually, this one, when does he is appearing, report was.
Who?
And that's one.
Who's in that?
Record was called for my lord.
So should we put a garland out there so that he can come?
Yes, my lord, I had already asked him after some time. Because he is.
So you are not aware?
Yes, actually,
So
because
we'll
I have
put a
not.
notice that the Advocate General is not, put a notice that the counsel for the government is not ready.
No,
And as such,
No,
the
my lord.
matter be, put a notice to the secretary for whom? Revenue?
no, my lord, in fact, my lord, he informed me that he will do the case, my lord, that is,
No, he is informed, I am not concerned when the matter is reached. This is a 2015-16 matter, it has to come up. If you are not aware, then it is okay. Well, on the matter being taken up,
yes, my lord, because my lord, this is a bench 5 matter,
The
my lord,
counsel-
because he is.
bench 5, bench 4, I am not concerned with this. When the matter is come up before this court, under the authority of the Chief Justice, the matter I can take it. Upon the matter being taken up, Mr. M. Setia, the learned counsel appearing on behalf of the government, and more particularly the circle officer, Dispute Revenue Circle, who was responsible for issuance of the notice dated 29/10/2018, submits that he has no knowledge about the matter.
No, my lord.
Considering the above, comma, let a notice be issued to the secretary, to the government of Assam, as well as the revenue, government of Assam, Revenue and Disaster Management Department, as well as the Deputy Commissioner, Kamrup Metro. Yes. Tell me whether this petitioner in that Prafulla Datta is in government land or in any other land? I'm asking you, do you know or not?
At least sometime, let me.
This matter has been going on from 2016. Does it take so many years for a government counsel to assist the court?
We have received today only by around.
I'm not concerned when you receive.
Only sometime.
Sometime, mean?
10 minutes and this. 10 minutes. Let me go through at least the record.
You are not aware of the matter.
I have got around 10:30, my lord, it's a record.
You have been appearing in this matter from the earlier.
Yes, my lord. On the last
You
occasion. an
appeared
order
on
has been passed.
3/9/2025.
Yes,
The
sir.
only issue out here is whether the petitioner in WPC number 7852 of 2018 is in government land or not.
Only 10 minutes. Only 10 minutes. I have got this record around 10:30, my lord. My friend is very aware of it, is fully aware of it, my lord. Now the last request and order has been passed. The record is not available. The DC will have to make a personal appearance or either will file it. If is setting the procedure has been taken to file on that. So some of this record is an old record, it has been found.
Give it to
Around
me.
10:30 I have been done. Only 10
Give
minutes,
give
my
it to me.
মই কেনেকে জানিম তোমাক ৰেকৰ্ড দিছে নে নাই মোৰ কথা কৈছে
lord. Like 10:30 দাদা মই নিদিওঁ।
মই কেনেকে জানিম মোক যে কৈ আছে সি আছে তুমি
No, no, please, last question যদি record আনিলে মই debate file কৰিব।
মই সেইটো কোৱা সেইটো মই
record
কোৰ্টক
মই
কৈ
আনি
দিছো
নিজে চাব পৰা নাই মই
মই সেইটো কোৱা নাই মই কেনেকে জানিম
Dock number 100 is Sarkar, government land.
they say
You are in dock number 100
Doug number 100
and dock
Then-
number
then-
100 in the Chita is maintained as government land.
then they said initially I don't know it in the affidavit they said that there was no demarcation of the land that this is a government land or forest when I made an application it is I have annexed those documents.
No, what they have done is a different thing, but the matter is very simple. Now it is a government land and the thing that you have filed an application is a self-admission on your part that you are in government land.
I admitted, I did not say we are not, but when we said that there's required to be a settlement, then they came up and said there is no demarcation. Since there was no demarcation, we cannot settle the land with you. Then I made an application, then there was some, the matter was also proceeded to particular certain extent. Those records, I don't know whether it is there or not, but it went to the records were called for by the I think Commissioner,
Mr. Chaudhary, has your land patta been cancelled?
No, no. There's not.
But here there are steps being taken for cancellation of your patta. Sir Nayak, as an additional advocate general, it appears that this land is a part of the reserve forest.
Yes. Some point of that, fiction was carried out in the entire area.
But here patta has been issued and therefore steps have been taken for relocation of the land of Mr. D. Chaudhary's clan.
That is,
Huh?
the present case is concerned. Initially, GMT issued section 7. Thereafter, during the cleaning notice, it came out that the concern sort of in the government. According to the, it was ascertained from the settlement of the, that was the government. Subsequent, that case was forwarded.
That is understood. One is government land and the other is the reserve forest. Now, if we see out here, it appears from the records that there is a move for the purpose of reallocating the dag or relocating the dag of or the land given to Suren Talukdar. Now I think he's died.
No,
And his wife, Rebati,
Wife died.
wife.
he is alive. He is alive.
Okay. In the name of so and so be given to his heir relocating this particular dag. This is what has been done in 2022. See, regarding the cancellation of the relocation of KP Patta number 7, dag number 100, 108 of village so and so under Muda. With reference, I am directed to enclose here with a copy of the letter under reference along with its enclosure received from the CM Secretary regarding cancellation of allocation of so and so. Under in this connection, you are requested to submit a present status report. This happened in 2022. This is given by the Land Settlement Branch. It further appears from a letter of the Deputy Commissioner Kamruk that this land was initially a part of the 990 bighas of land earlier allotted to the Forest Department for reserve forest. But the reserve forest did not utilize it. As per the record, there is no patta land and therefore the land was given in the settlement was made in his favor. But the fact remains that if the land is been made a part of the reserve forest, then how can be de-reserved without the permission of the Ministry of Environment? Wouldn't it be in violation of Section 2 of the Forest Conservation Act?
In this case, there is a big one declared by the popular authority. And therefore replaced in the second, and therefore replaced with kindly cancel. Name of Suren Talukdar.
Ah.
In his file by creating a new dag number 108
And give it in some other place. So the relocating the petitioner out there in the 2016 with petition to some other place.
that was the earlier.
And the petitioner here, Prafulla Dotto, getting any settlement does not arise if it is a reserved land.
But so far as the complaint is concerned, and the finding of the hearing of popular Gupta constructed and put some portion of the not land in our city. It was found and that portion is open. For the status of the land of the not here. Fine.
No, but the fact remains that if he is asking nearby,
Not popular. When Talukdar is asking nearby.
no. His case is that he is asking for the nearby land of Surendra Talukdar. It's there. Just
No, we are just in next door neighbors, next door neighbors.
And if it is a part of the 990 bighas of land which was reserved for reserve forest, but it was not used. Whether there was a declaration made,
It is not earlier also.
One instruction I have received, my lord, clearly state that
here the question of cancellation of the patta of the petitioner out here does not arise, of that petitioner does not arise. You may have to acquire it. You have to already settle it with him. You may have to acquire that land and give it to him or relocate him wherever maybe that is a different aspect of the matter. If you want to, because he has a patta holder. But as regards this petitioner, he cannot be settled with that land if it is a part of the Amsing Reserve Forest. And then it is the forest department who should issue notice if that be so. And on what, you see, you have to take this information. This particular document has relevance, I think. Have a look at this document. Okay. Kindly see this document. This is done at the instance of the CM Secretariat. So therefore, most probably during that period when all this thing was going on, the eviction which were going on, this was one of the issue which were cropped in. And therefore steps were being taken for the cancellation of that patta and relocate it in some other place of that petitioner. And consequently, the question of the settlement to be given to him does not arise. If it is in the reserve forest, or even in the when you are on one hand, the government is trying to cancel his patta and relocate him in somewhere else. Where is the question of granting him settlement?
Earlier instruction also, when I had says matter Apo Beltola Mojar, Dono, Monka, Sorkar is a bit popular doctor or posting for a document on for it. But it never stated that it's come under the forest.
It appears therefore from a part, it was from this letter. So that's finally see this map. If it is the settlement can only be given to him if it is a government wasteland. If it is not a government wasteland, it cannot. But if you see the settlement order passed by the deputy commissioner in the case of Suren Talukdar, it's in that file. Have you got that? No, it is in the first page, earlier house.
2005, my.
Yeah, 2001.
No.
Before, at the top.
2005.
No, 2005 settlement had happened. But earlier to that, there's one paper out there. No, not there. Something like that paper. Didn't it say to be a forest land?
For the letter of finance, for the বিষয় প্রসঙ্গ লিখিত চুক্তি সন্দর্ভত এখনম দাগৰ মুঠ 990 বিঘা জমি চৰকাৰৰ 7/4/91 তাৰিখৰ RS নম্বৰ 2 কুম ফৰ্মেট বন বিভাগৰ নামত যদিও ইতিমধ্যে হুকুমপাৰ আগৰে পৰা উক্ত জমিত প্ৰায় 500 বিঘামান জমি দীঘল বিভিন্ন লোকে
But that must have been something to do with the eviction. Was the eviction done in that area?
বৰ্তমান উক্ত দাগত বন বিভাগৰ নথি সংশোধন হোৱা নাই বন বিভাগক সৰজমিনৰ যুটীয়া তদন্ত ক্ৰমে দখল যায় নথি সংশোধনৰ বাবে জনোৱা হৈছিল দখলকাৰী তন্ত্ৰৰ বেদখলকাৰী সময়ত It was continuing in 2000.
Since 1991, 7491.
Subsequently, 2005, land has been settled in favor of Suren Talukdar.
No, the reason has been given by the deputy commissioner in that letter. Show it to you. Let me show it to you. Give me the file.
7/3/2000.
Show it. This one, 2001. Yeah, you get this. It is mentioned out. But the fact remains, you may allot a particular plot of land to the forest department. But to reserve the land, the forest department has also to take action in terms with section 3, 4, 5, 6 to 15 of the Assam Forest Regulation. I don't think the forest department has done to that effect. Huh? It appears. So therefore, it remains as a government wasteland. But if that is so, why this direction given by the CM Secretary for relocation, cancellation of his patta and relocating him to some other place? Because this is very relevant. I think this must have anything to do with, something to do with the eviction which was carried out. And to make this Amsing Reserve Forest a proper forest area to that effect.
Eviction was carried out just because it was the forest.
No, that eviction was it with regard, I did one case in that with regarding that eviction. That was in a forest land area which was just next to the forest. Here, your lordship, the Guwahati, on one side is the land of Suren Talukdar On the other side is the Guwahati Public School, and then totally the area is totally the whole area is inhabited by people. There are buildings, 2, 3, 4 story buildings are also there, and in between that, this the popular doctor's house is just in between that, and then road is on the other side. So there is something is, I don't know, there is amiss. This is why it took a very long time to get into, because they have also issued the commissioner, I think the lower, at that point of time, the lower Assam commissioner, Commissioner Lower Assam has also directed for inquiry into what exactly is there in this matter. That was done in 2020. Then the report is not there. I don't know, because it was never submitted by them. We have annexed the document in one of our additional affidavit with regard to the inquiry made with what was the present status and how the land is functioning as of now. That was in 2020.
The land, it's an unpaid fact, the government land has been settled with Suren Taluk. Here case is that, my lord, they are also residing in the same nearby one. That is also falls under Dock number 100.
Now, it appears to be that these are those 500 people who have already encroached upon the government land. And if you see prior to these 2, 3 documents, there is one document by which 9 or 10 proposals have gone for settlement, including that of Suren Talukdar. Suren Talukdar happened to be one of them who were granted in the SLCP.
Yes, from 98, what I have done to the.
98.
I think he has made a first application. Around
98, his application was there, and he therefore that order, as I said, is of 2001. The records were corrected. Patta was issued in 2005.
this record, my lord. You said today only around 10:30. Right.
Because the question of if the government is now intending to make it a forest land, a direction by this court upon consideration of his application for settlement. This court cannot grant a settlement. Consideration of would not be proper. It may be that the petitioner may be, if you see the land policy out here, the land policy prescribes that he has no right to get a settlement on the land where he is. But if he has no other land, if he is an indigenous person, he is very much entitled to a plot of land within the area. If it is nearby area, it will be in Guwahati itself or in the urban area, 1 kata 10 lectures. That's the area he can get it out there. And if it is beyond that, it's much more. It is there. But if he may be entitled to some other plot of land for consideration. So that is the order can be passed. But if it is, but from there it doesn't appear that the reservation proceedings have happened. And more particularly that even after that, the forest department is not willing to take over the land.
The meantime, I'll try to take a present status of this letter.
Who?
I'll try to take a present status of this letter.
This letter also take the present status because this will have an implication as regards which may be a subject matter of a challenge being made by Mr. D. Chaudhary at a later point of time. Okay, let me pass an order. We'll have these instructions next week. Heard Mr. D. Chaudhary, the learned counsel, appearing on behalf of the petitioner in WPC number 4591 of 2016. Semicolon. Mr. Y.S. Manan, the learned counsel, who appears on behalf of the petitioner in WPC number 7852 of 2018. Mr. N. Das, the learned counsel, Mr. P. Naik, the learned petitioner advocate general, who appears on behalf of the government of Assam as well as for the GMBA. I've also heard Mr. N. Das, the learned counsel, who appears on behalf of the Deputy Commissioner, Kamrup Rural,
Metro.
Kamrup Metro. Both the petitions are interconnected. The writ petitioner in WPC number 4591/2016 admittedly have been allotted a plot of land, admittedly have been settled with a plot of land at measuring 1 kata 10 lecha, covered by dag number 108 of patta number 7. Of village Zonsimalu
John Simalu.
Nonke under Musa Beltola in the district of Kamrup Metro, Assam. The grievance of the petitioner herein is that the respondent number 7 in WPC number 4591/2016 have raised construction over the government land and have also tried to encroach upon the land of the petitioner, for which appropriate redirection and order have been sought for. It appears that pursuant to the instant writ petition being filed, the circle officer of Dispur Revenue Circle had issued a notice dated 29/10/2018 upon the respondent number 7 in WPC number 4591/2016, thereby directing him to vacate the land, which is the subject matter of challenge in WPC number 7852/2018. At this stage, it is very pertinent to mention, take note of the submission of Mr. Y.S. Manan, the learned counsel, appearing on behalf of the respondent number 7, who is also in WPC number 4591/2016, as well as the petitioner in WPC number 7852/2018, that pursuant to orders being passed by this court, the construction which was made by the petitioner in WPC number 7852/2018 have been stopped, and the infringing portion of the construction which was encroaching upon the land of the petitioner in WPC number 4591/2016 have been demolished. Mr. D. Chaudhary, the learned counsel, appearing on behalf of the petitioner in WPC number 4591/2016, shall take appropriate instruction as to whether there has been demolition carried out. Next. This court further duly takes note of the notice, further duly takes note of that the relief which have been sought for in WPC number 7852/2018 are twofold. First is the challenge to the notice issued by the circle officer, Dispur Revenue Circle, dated 29/10/2018, whereby the petitioner, that is Prafulla Datta, have been asked to vacate the land in his possession. And the second relief which have been sought for is the is appropriate directions for consideration of the prayer for settlement made to be made in favor of the petitioner. During the course of the hearing, this court inquired with Mr. P. Naik, the learned counsel appearing on behalf of learned additional advocate general, who appears on behalf of the government of Assam, as well as the GMDA, as to what actions have been taken on behalf of the GMDA, taking into account that the respondent, the petitioner in WPC number 7852 of 2018, admittedly has constructed over a land, have constructed it without taking any permission. Mr. Pina, the learned additional advocate general, had submitted that on coming to learn that the petitioner, that is Sri Popular Datta, had constructed over government land, the GMD authorities had remitted the matter to the deputy commissioner for taking appropriate action, and it is on the basis thereof the notice dated 29/10/2018 have been issued by the circle officer, Dispute Revenue Circle. This court further perused the records which were produced by Mr. N. Das, the learned counsel who represents the district administration of Kamrup Metro. From a perusal of the record, it reveals that the petitioner in WPC number 4591/2016 have been settled with the land after taking premium in the year 2005 itself. In the very settlement order made by the Deputy Commissioner Kamrup in favor of the petitioner in WPC number 4591/2016, there is a reference to an order passed by the government of Assam dated 7/4/1991, isn't it? 7/4/1991. See the settlement order of the Deputy Commissioner of 2001.
7/3/2000.
7/3?
2001.
No, the government's order. 1991, 7/4/1991.
No, he couldn't be.
No, not on top. In the middle. Okay, continue. Very cool. Seven four 1991. You are, Pastor, you are reading 7/3/2001. Inside it is written. There is a mention of an order dated 7/4/1991, whereby 990 bighas of land was allotted by the government to the Forest Department for reserve forest. However, the Forest Department did not utilize the said land. And the government of Assam thereupon had settled lands with various persons, including the petitioner, being WPC number 4591/2016. The reference to the said aspect have been drawn. It can be seen. The said aspect is apparent from the order of the Deputy Commissioner dated 7/3/2001, whereby the land was settled in favor of the petitioner in WPC number 4591/2016. The question therefore arises is as to whether the petitioner in WPC number 7852/2018 would be entitled to settlement, taking into account that the land wherein the petitioner in WPC number 7852/2018 is seeking settlement is adjacent to the land of the petitioner in WPC number 4591/2016. This court fixes this matter again on 27th of October 2025. Yeah, yeah, yeah. This court further, upon perusal of the records, also finds a document, an undated document of the year 2022, issued by the branch officer, land settlement branch, to the circle officer, Dispur Revenue Circle, wherein there is a reference pertaining to cancellation of the relocation of KP Patta number 7 of dark number 100 bracket pole oblique 108 new, which was the land allotted to the petitioner in the application number 4591 oblique 2016. That too based upon some communication from the CM Secretariat. Under such circumstances, it is therefore the opinion of this court that certain instructions are required for the final adjudication, for an appropriate adjudication of the instant proceedings. Mr. P. Nayak, the instructions therefore sought for are as hereindunder. Number one, the Mr. P. Nayak, the learned Additional Advocate General, shall apprise this court as to whether there is any move on the part of the government for entrusting this entire entire land contained in dark number 100, including the land which have been allotted in favor, settled in favor of the petitioner in Deputy 4591 of 2016. For the purpose of reserve forest, as was sought to be done on the basis of an order passed on 7/4/1991. Number two, was any action taken on the basis of the communication issued by the CM Secretariat regarding cancellation oblique relocation of KP Patta number 7 dark number 100 bracket O oblique 108 bracket N of village Sanai Simalo NK under Moza Beltola. Number three, whether the land in dark number 100 of village Donasimalu NK under Moza Beltola continues to remain as a government wasteland as on date. Number four, whether the government, whether the forest department of the government of Assam had taken any action pursuant to, in terms with the Assam Forest Regulations 1891, pursuant to the order dated 7/4/1991, issued by the Revenue Department of the Government of Assam towards reservation of the said land in dark number 100 of village Swat. Please take.
Can it be in a this remix? Can it?
No, 27. Therefore, I am asking Additional Advocate General. He appears for everybody. List according. You see, all these are interconnected. Whether there is a question of relocation has to be on the basis of what decision was taken pertaining to the Upsing Reserve Forest, that is the eviction ban. Because the Upsing Reserve Forest, there was an eviction ban. Secondly, as to whether it continues to be a wasteland or not. If it is a wasteland, he can grant that his application can be considered. That's all. And Arata number 4, last thought before. Last thought that was. Mr. Y.S. Mr. D. Chaudhary, the learned counsel, appearing on behalf of the petitioner in WPC number 4591 of the 2016, shall obtain instructions as above stated as to whether the infringing construction area, infringing portion of the construction made by the respondent number 7, that is Profulla Datta, towards his land have been demolished.
In RPS, it's taken 29, I will not be. Can it be on second?
I'm on 27, not on 29.
It's a Monday. Next. Bill Prayer. Can it be on 3rd November?
Why?
It's a thing, we originals for the year.
So?
Sometime.
You don't know the power of Mr. P. 27. 27. All matters. And once that is done, I think Mr. Chaudhary, you should withdraw if that is being demolished. Because further going into that aspect into your matter will have a lot of complications for you as regards relocation. Huh? Later on. First, you need to, once you, if this infringing portion is gone, that is why I asked you, so that you can be taken out from there. And he will only, once it is, we get the instruction, it is a wasteland. We therefore say that he will submit his representation, it will be considered matter over as per the land policy. But this is just making it clear. But I cannot direct if there is a decision of the government to reserve it as a reserve land. Reserve, then it becomes very difficult. Then you may have a problem. For that, you may have to withdraw. And the move for relocation gives the flavor that there is a direction for the government to reserve it. Otherwise, why will the government CM Secretary write for relocation of his land? That is must be the basic reason why. Because that is the instruction I made it. We can have it on then 31st. 31st. You get your instruction. 30. Yes.
My lord, I couldn't get any instruction. I can communicate with the same.
You need not take any. Heard Miss So-and-so appearing, who appears on behalf of the petition. And Mr. N.N. Upadhyay, who appears on behalf of the petition. The petitioner herein has approached this court. Challenge being aggrieved at the non-payment of the admitted outstanding liabilities due to the petition, as reflected in the report of the respondent number 5 dated 1/8/2014 in respect of Kalapani irrigation scheme construction of headworks of Kalapani I/S, including dewatering, etc., as well as the terms of admission made in the letter dated 28/2015 issued by the chief engineer, bracket MI Irrigation Assam. The petitioner lays emphasis on the report includes as Annexure K and report date Annexure marked as Annexure K, wherein it has been mentioned that the petitioner was entitled to an amount of rupees 85,85,896. Pursuant to the filing of the instant writ petition, an affidavit was filed by the respondent number 2, stating inter alia that the tender work was worked allotted to the petitioner and further stated that the matter of payment against the work implemented by the petitioner is now with the government in the irrigation department and the approval on the matter is awaited. On receipt of the government approval of sanction of the fund, necessary arrangement will be made as required. It was further stated that the petitioner was paid for non-completion of the Bhulanat Fund scheme, which needs to be made recovery from the petitioner against the bill amount at the time of payment. This affidavit was filed on 2nd of November 2018. Subsequent thereto, an additional affidavit has been filed on 12th of June 2024, wherein it has been mentioned that the entire amount of up-to-date bill value against work allotted and completed in the Bholanath Band by the petitioner was to the tune of rupees 37455882, and the same was duly paid. It was further mentioned that an amount was recoverable from the petitioner to the tune of rupees 62,42,396.94 as per the statement. From the materials on record, further to that, it has also been mentioned that though the chief engineer submitted the same to the government in the irrigation department for the approval, the same was not approved by the government on the aforesaid reason, and hence the payment claimed by the petitioner to the tune of rupees 85,896 in the present petition cannot be paid. The materials on record, therefore, from the materials on record and upon hearing the learned counsels for the parties, it therefore appears that there are disputes as to whether the petitioner is entitled to any amount, or the irrigation department, on the other hand, is it to recover any amount from the petition. Considering the same aspect cannot be decided in a writ proceedings wherein evidence cannot be led. Under such circumstances, it would be best, the petitioner would be under such circumstances, the present writ petition cannot be entertained on the ground that that disputed questions of facts arises as regards as to whether the petitioner is entitled to any amount, or the irrigation department is on the other hand entitled to any recovery from the petitioner. Consequently, the instant writ petition therefore stands dismissed. Before parting with the record, this court, however, observes that taking into account that the instant writ petition has been dismissed on not being entertained, and the petitioner had been bona fidely pursuing the present litigation, the petitioner is given the liberty to approach this appropriate forum wherein approach the civil court of competent jurisdiction, if so advised, and the period from 21/5/2015 till date be excluded while computing the period of limitation. I looked.
May I please, Your Lordship?
Yes,
Conducted counsel is on Lakes on court number 52, DP Bora
Vicky Bora,
is in Lakes, Lordship. This matter may be passed out for timing.
what is the matter about non-payment? What is the
We have filed our.
affidavit filed?
Yes, madam.
What is the stand?
Madam, so far, our stand is, we have paid the amount, madam. And he has claimed it.
In verification option, the petitioner submitted the bill of so and so only, and it was checked by the upon taking the petitioner was requested to the could not submit it to Kalat. So 7,40,000 you have already
Yes,
paid.
madam. For that,
Amount of rupees 2,98,000 the petitioner could not substantiate.
Yes.
It's matter,
question of court.
go to the civil court. Therefore, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. G. Bukel appeared on behalf of the respondent numbers 2, 3, and 4. None appears on behalf of the chief electoral officer, Sam, when the matter is called. The petitioner herein is aggrieved on account of non-payment of an amount of rupees 1,80,055, which the petitioner on account of the on 1,80,055, to which the petitioner claims to be entitled on account of supplying of food items. The record reveals that an affidavit in opposition has been filed on 17th of November 2022 by the respondent number 2, wherein it has been mentioned at paragraph number 5 that during the parliamentary elections of 2019, the petitioner submitted a bill of rupees 7,40,943, and the same payment, said amount, to have been duly paid to the petitioner. Further to that, it has been mentioned that during verification of the outstanding liability of the said election, the writ petitioner submitted a further bill of rupees 2,98,719, which was checked by the then additional Deputy Commissioner Kasip Sagar. However, upon checking such bill, the writ petitioner was requested to submit the supply order and copies of the challans which are required for payment. But the writ petitioner could not submit any document in support of the said claim. So this court further takes note of that pursuant to the filing of the instant writ petition, no reply has also been filed substantiating the allegations mentioned in paragraph number 5. Considering the above, the court is not in a position to direct payment of an amount of rupees 2,98,000 to the amount of rupees 1,80,055 as has been sought for by way of the present writ petition. Accordingly, the instant writ petition therefore stands closed. Be that as it may, the petitioner herein is given the liberty to approach the court of competent civil jurisdiction, if so agreed, and the period from 6/9/2022 till date be excluded while computing the period of limitation.
18,
In this case, we will file an affidavit today also. Non-payment of contractual business. We will file an affidavit today.
When?
Today.
What do you say?
This claim is for 14 lakhs something. Then we verified and we found that 9,26,000 is. This claim.
Where is the affidavit?
Paragraph 5.
পাইছো।
তিনটা আসলে এটা দিতে পারছি
এই আগৰ স্কিম স্কিমত এইটো এমাহৰ ভিতৰত মানে চব ভেৰিফাই কৰি যদি পইচা থাকে 3 মাহৰ ভিতৰত দি দিব সেইটো দেখাই দিম চেম স্কিম।
It has been submitted by Mr. S. Soto, the learned counsel appearing on behalf of the Revenue Department, that an affidavit in opposition has been filed on behalf of the Joint Secretary to the Government of Assam Revenue and Disaster Management Department. In the said affidavit in opposition, it has been mentioned that from the report received from the District Commissioner Majuli by letter dated 7/10/2025, along with the documents enclosed thereto, including the work orders dated 30/11/2018 and 24/9/2019. The value of the work allotted to the petitioner comes to rupees 9,26,232. Whereas the amount claimed by the petitioner is rupees 14,15,419. The learned counsel appearing on behalf of the petitioner submits that upon receipt that in view of the stand taken in the said affidavit in opposition, the petitioner would like to file a reply as regards its entitlement. Considering the above, list this matter on 10th of November 2025. In the meantime, the petitioner shall be at liberty to file the reply on or before 7th of November 2025.
19,
Very good. What is this?
Kali, where is the last order dated?
Well, look, we have received instruction and found this admitted. Found this admitted.
Part payment has already been made, my lord.
Huh?
Part payment has already been made.
How much?
My lord, total amount was 3 crore 73 lakhs 13,213. Out of the same, my lord, 2 crore 93 lakhs 38,483 paid. Now remain, my lord, 79 lakhs 74,730.
Yes, ma'am. We have admitted the amount, but however, this amount will be released by the year. Disaster management division.
We have received some instruction. Certain documents have been from the district commission. That has not been received by the department.
Okay, we'll give you 2 weeks time, file your affidavit. Make whatever verification it is there and file an affidavit with the First, Mr. R. S. Dr. Learned Counsel for the Revenue Department submits that certain inquiries have been made with the district commissioner as regards the petitioner's entitlement. First, Mr. G. Bukel, appearing on behalf of the district commissioner, however, submits that the amount has been admitted by the district commissioner. The same be brought on record, the stand of both the revenue department as well as the district commissioner be brought on record without fail on or before 12th of November 2025. List the matter on 17th of November 2025.
Much of it.
item 20,
May I please, your lordship? My matter may be kindly passed for timing, your lordship. My senior is
Huh?
late in code number
What is
22.
this,
here.
2014? Which petition is pending? Pending?
Yes, sir.
14 is pending,
No. That was,
disposed of.
yes.
Okay. No, I don't. Disposed of. Now, what is this 2025 petition?
My instructions are related. I'm seeking some time.
Why?
In fact, Worship, the service copies were filed, even on the last day, Worship, I have transmitted that.
It was given to you
On the last day, Worship,
Yes.
on the last day, Worship.
on 26/9,
Last date.
11/8,
Yes, sir.
and then
Worship, I have forwarded it, Worship, instructions are related, Worship.
what does he want? Mr. Architect Chaudhary, the learned counsel submits that one further opportunity may be granted to obtain instructions and file the affidavit. First of all, taking into account the above, this matter on 12th of November 2025. In the meantime, the affidavit be filed on or before 10th of November 2025 by the respondent.
Okay.
21,
Non-payment,
Milo.
what is your stand?
My senior, Ekip
Is your senior?
Senior Ekip has been newly appointed as standing counsel BTC. So we don't have the brief as of now. We have just submitted before the registry about the appointment. So we'll be appearing in this matter called BTC.
Page 26, the report, man. Page 26, the report of the executive engineer. Part payment has been made. Page 26.
It has been submitted that there is a change in the it has been submitted that Mr. A.K. Bhuya has been recently, the Learned Council have been recently appointed as the as the standing council of the BTC. And therefore seeks for some more time to file the affidavit. Was to list the matter on 10th of November 2025, on which state the BTC authorities the BTC shall apprise this court as to whether the amount claimed by the petitioner to the tune of rupees 53,90,977 is outstanding and payable to the petitioner. And if so, when the said amount can be paid.
22.
This is in regard to cancellation of the tender process and re-tendering, my lord. Well, may I just give a short note is there, along with judgment relied upon. Only one page.
Yes. What is this?
Now I've given a small note there.
You have to produce the record. You will produce the record.
But one page will do, my lord. That is the crux of the game.
Yes, what is the case, Mr.
My lord, it was, the tender was open. Those are judgment, your lordship judgment is also there. I find it covers our case also.
What happened? My judgment, what is there?
Your lordship judgment at paragraph 27, flexi. There are also similar case where tenders were opened and thereafter it was cancelled. Your lordship interfered on the ground that there is no viability range.
Huh?
There is no viability range because here the initial bid value was, bid amount they offered is 75 lakhs. Then they opened the bid, then after comparative statement was made. Then thereafter, my lord, they have cancelled it on the ground that the bid which has been received is too low. The four bids are there. It is more than 2 crores, 83 lakhs. The petitioner has himself quoted 1 crore 43 lakhs. Now the tender has been issued saying that they have increased the bid value by from 75 lakhs to 1 crore. And the reason given is a cancellation order, if your lordship looks into it, that is at page 46. Tender was for 2 vehicle gates. One has been settled, but one has been retendered. And 47, your lordship will kindly see, executive committee's resolution that is dated 24th April 25. And the cancellation order is 19th April 25. In the comparative statements, your lordship may kindly see at page 132.
So the reason assigned is that the order of cancellation as per direction of the council and to retender by increasing the value from 75 lakhs to 1 crore.
Yes.
Why?
And that also the date, your lordship will kindly see. Executive committee resolution's date is 24th April and the cancellation order is 19th. And comparative statements, if one looks into, it is the tenders are valued at much
Press
higher
NIT
rate.
state,
Hello,
press NIT state.
NIT. NIT is at page 20. NIT कहाँ है?
Press NIT state.
Page 27. ma'am. NIT is at page 27. It was for 2 gates. One
Let us
gate
see
has
the
been,
NIT, where is it?
page 27. Huh?
Wait,
Fresh NIT is page
39,
39.
33.
Uh,
Where is the
34.
NIT for which you were issued? So you quoted 1 crore 43.
43. ma'am.
That was not given to you.
Not given to me. There are persons above me. I'm challenging the cancellation. Whoever is entitled, my lord, they may be given. My knowledge is, my lord, the other persons above me are, they are not, they are withdrawing. But whoever is given, I am agreed by the order of cancellation. My lord, without any,
Where is your comparative statement?
that is at 132, man. That they have annexed with their affidavit.
You have quoted, what is your name?
Next page, my lord, page 133,
Uday.
serial 10.
Ali. Yes, why are you cancelling it?
The tender notice has been issued for 2 gates. One gate is Mandadista gate and the another is Ditoktera vehicle gate. And this instant case is for Ditoktera vehicle gate. Also for the other gate, which is the Mandadista vehicle gate, the tender rate for that was 75 lakhs 37,500. And in that particular gate, we have received the tender offer, we have settled the gate, the one with the person we have quoted the rate at rupees 5 crores. So expecting the higher revenue for the other gate, we have done for the fresh tender.
My goodness, how can you? If that be so, now also you are thinking of fixing it 1 crore.
1 crore.
Then why you are not putting it at 5 crores?
Also in earlier date also we have, the rate was only for 75 crores, but 75 lakhs, but there we got 5 crores more. This time also.
All understood. But the fact is, why did you take a decision now that instead of 75, let us have it at 1 crore now?
Also in
Isn't it? Kindly come to page 133. The official rate of Dictura Vijay paid is 75 lakhs, which is very minimal of 1 crore, for which tender process should be done immediately by cancelling the tender. So now you want at 1 crore. And he's putting 1 crore 43, you are not giving it to him.
also, as per the calculation that we have got from the Mother Teresa gate, where we got more than 3 crores. As per the calculation of the register.
Then why on earth did you put at 75 lakhs?
But initially, the flying of the vehicles was very less, but subsequently we came to the knowledge that the flying of vehicles have increased. Because of that reason only, we have increased the, we have gone for the fresh tender, increasing. the
You
rate.
knew about it. You earlier quoted 1 crore. Didn't you get a 1 crore earlier? Which was cancelled. Didn't you give at 1 crore without a tender process earlier?
Another tender for their loss. After that.
Then you came to know. When the court interfered with it, then you now make it at 75. And now want to give it at 1. You are not giving it 143, the double you are not giving it. Now you say that you will get 5 crore. Is this how you run your business? NC Hills runs the business in this manner. Tomorrow you may say, okay, 5 crores, well, why not 10, make it 10 crores? Now who is running the gate?
Gate is run by the department also. As after the interim order passed by the summer. Getting all the knowledge that the revenue will be increased, we get the higher tax. That's why this retender.
But this is for which period?
For the period till December also.
So you till 31st of December.
Also.
Now you will pay 1 crore 43.
Yes.
Till December.
1 crore 43 lakhs, I mean, proportionately they will have to be fixed, I think.
I mean, God say, but the petitioner is the
Proportion-
highest bidder. The fourth highest bidder.
Let the highest
You
bidder
give
get
it
it.
to the highest bidder. Whoever it is,
Whoever.
whoever accept. If somebody does not accept, you have a clause out there. See the notice inviting tender, page 28. The tenderer must quote reasonable rate against each market area. Any tenderer quoting exorbitant rate and later surrender the tender at a time of settlement will be penalized with a fine up to 2 lakhs. Only from the tender value of rupees 10 lakhs or above rupees 50,000 for tender value below 10 lakhs. Exercise that power in respect to those who do not accept. Take 5 lakhs each. 2 lakhs.
Also with this,
What an-
again, they're taking the revenue also. Also.
What?
saving. If the press tender.
They have it for 2 months, November and December. And thereupon, this should be only given for 2 months, only till 31/12 on a proportionate rate. Whoever it is, give it only till then. Thereafter, the petitioner has no right. But you cannot do like this. This is never heard of. This is the first time I have ever heard hearing such thing.
Also to the, one of the judgment passed by the coordinate bench of the Supreme Court, they were also relating to the LPG gas cylinder, wherein of the IMFL lordship, when there, when in the tender was for 4 districts, and when they got the higher rate from the other district, then for one of the districts, if they have gone for retender, taking the higher tender that they have received from the other district. That has been allowed. It's been- Seven district. Seven district, four temples.
Extra copy আছে নাকি? Report. कितना है?
Nine. The religion developed is around 19. Page 5.
क्या लिखा है? पैरा cancellation. Note that.
Okay, now you say that you will earn more revenue. Okay, you have been running this from last how since when? You've been running this, na? Running this gate since? One five 2025. Are you not running it? One five 2025. Okay, next week, bring the details, how much collection you have made from then till today. We'll come to know
Yes.
if that is the reason. Because
In
you
I-
say that you can collect more. So we will see if it is then proportionate or not. Although that judgment may not squarely apply, taking into account that there was only single tenderer. Secondly, there was an section 114A of the Assam Excise Act was applied, which is not here. That is another aspect. But then also one aspect otherwise is there, that if the state can get more revenue. Now, if you have got more revenue from 1/5/2025 till date, proportionately to what the petitioner have quoted, very well, you continue. You need not, but you produce it next week, the details.
my lord, I have shown, my lord, year before they have given it 50 lakhs.
No,
Then
it's
they have
okay.
given directly
No,
at
we'll
1
see
crore.
that. Let them produce it. Because they cannot come up here and say that. We'll have it next. Because the matter having been heard at length, heard Mr. P.D. Das, the learned senior counsel, assisted by so and so, appearing on behalf of the petitioner. Mr. What's your name? D. Towson appeared on behalf of the NC Hills. The petitioner is aggrieved by the action on the part of the respondent authorities in cancelling the tender notice dated 26/3/2025 and further issuing a fresh tender notice dated 22/4/2025. Isn't it? 22. The grounds and reasons assigned in the affidavit is that there were two gates which were auctioned by the tender notice dated 26/3/2025. One of such gate being Maderdisa Vehicle Gate have been settled at rupees 5 crores. Whereas in the gate in question, that is Ditokchara, Dittookchara Vehicle Gate, which was fixed at 75 lakhs in the tender notice. The highest bid submitted as per the tender notice is rupees 1 crore 82 lakhs 630. Is 2 crores 87 lakhs 50,200. And the petitioner herein had quoted rupees 1 crore 43 lakhs 00900. It is the contention of the respondents herein that in view of the settlement at a much higher rate that of Maderdisa Vehicle Gate, the settling of the Tuchara Vehicle Gate at a lesser rate would affect the public interest. And as such, decision was taken for going for a fresh tender. It is noteworthy to mention that the vehicle gates in question were for a particular period, that is from 12/4/2025 to 31/12/2025. And it has been submitted by Mr. D. Towson, appearing on behalf of the Enso Hills, that since 1/5/2025, in view of the interim order passed by this court, the said Dituchara vehicle gate have been run by the department since 1/5/2025 till date. So considering the above, list this matter on 24th of October 2025, on which date the learned counsel appearing on behalf of the department, the NC Health shall produce details as to what has been the monthly collection, what has been the collection since 1/5/2025 till today, as it is today, till today, and along with the monthly breakup from the Dituchara vehicle gate. List recording. Records so produced are returned to be reproduced again on the next date.
No, it's for further hearing, further hearing. Your Lordship has heard the matter.
It's okay.
23.
I'm here. Yes, Mr. Hawk, where is he? Oh.
Your Lordship, in this case, there is a new development.
Uh,
The appellate tribunal has passed status quo order.
who?
TRAT Kolkata.
Can't help it now. Next date is of 6th of November.
Yes.
Mr. A. Parvez, the learned standing counsel of the
Punjab National Bank.
Punjab National Bank, have placed before this court an order passed by, order dated 24/9/2025, passed by the Debt Recovery Appellate Tribunal at Kolkata, whereby whereby a status quo order as regards possession has been passed, which is valid up till 6/11/2025. Full stop. Taking into account the above, full stop. Taking into account the above, list this matter on 24th of November 2025.
Obligement.
Your Lordship. Lordship, matter regarding NRC, my lord, all the petition, family members' name is recorded in NRC, but petitioner name is not included, my lord.
Yes, what is your stand? Who is appearing for the NRC?
My humble submission is that their stage is not yet coming.
Huh?
Their stage is not yet coming. That stage is not yet coming, Lordship. I think, Lordship, it is a premature stage, Lordship. So, Lordship, the Register General of Citizens registration is required to publish the final national registers of Indian citizens in the state of Assam. And Lordship, the Register General of Citizens registration has not yet accepted the publication of supplementary list, Lordship. It has to be notified, Lordship. Till it is not notified, Lordship. So, Lordship,
So you say that the petitioner's name may be included in the supplementary.
Lordship, what is, Lordship, it's a premature death, this is not yet coming, Lordship.
Only that is, then only you can say it to be premature.
Yes.
So the name the final notice, final publication is yet to happen.
Yes.
Of the NRC.
Yes.
And once it happens, then only the petitioner's question will apply. Now, the question is whether the question of claims and objections period is still there. Is it open? My question is that.
No, no.
If somebody's name has been dropped from the NRC,
Yes.
what is the person going?
Then Lordship, appellate provision is there, Lordship.
Huh?
Appellate provision.
Has the appellate tribunal been constituted for that?
No,
Then-
not yet, not yet.
Don't come up with all this type of plea before me. I'm asking you therefore, what is the person going to do? You see, when you are having the NRC, you have the first draft.
Yes, Lord.
After the first draft is over, you ask for any claims and objections.
Yes.
Claims can be made thereupon, objections can also be raised. Thereupon you publish the final draft, which you have published.
Lord.
In that final draft, the petitioner's name is not there.
Yes.
Now the question is, the petitioner is agreed.
Yes.
Where will the petitioner go? Or should it wait till the NRC is finally published? Or are you saying that NRC which have been issued has been a useless document and it cannot be put to use till
Yes.
that document is required, is being published by the Register General of whatever mean?
Okay. Yes, okay.
So therefore you consider her case. Consider a case. You say that it is not finalized. Very well, consider it. Petitioner has to have redress somewhere. And as she has no redressal, there is no appellate provision which have been put into effect till date. The petitioner has to approach this court under 226. And the petitioner has accordingly approached. Now you say that you will consider her case, then it's okay, fantastic, we'll close it. Petitioner would be happy, go back smiling.
Lordship, can you be on refer tomorrow, Lord? I will be the instruction. Refer tomorrow, Lordship. Will be what is going on there, Lordship. What is going on there, Lordship? I have taken instruction, Lordship. Let it come on refer tomorrow, Lordship.
Okay, we'll have it on 22nd.
Yes.
Get your instructions.
Yes.
Mr.
G. Sharma.
G. Sharma,
Yes, sir.
appears on behalf of,
Respondent number 1 and 2.
who is there? Who is 1 and 2?
2 and 3. 2 and 3, Lord.
Who is NRC? Are you appearing for NRC
Yes,
or not?
yes, Lordship.
Appearing on behalf of the NRC, submit that he requires some time to obtain instructions to establish this matter on 22nd of October 2025.
Item 25.
That's all the case to right.
Yes, what is this? Regarding non-releasing the security deposit and performance guarantee.
And why haven't you released it?
Well, that let be next week or 10 days.
Hmm?
10 days or next week.
No, your next week, every time next week comes. 28/7, 1/8, you give next week. It comes on next week, 1/8, then I fix after on 22/9. 22/9 again, nothing
I've
happened.
intimated the main liaising officer, my lord. They are looking at the records and it will be intimated. Friday next month.
You say last time that certain period is not.
Lordship, it has
Submits the, as well as the finance department submits that the period of maintenance has been extended to March 2027. He therefore submits that he has already received the instruction and file a short affidavit in this regard.
Tapos Kumar Chaudhary, last time instruction.
You say that you have received the instruction.
Well, in this brief, nothing is there. Well, let it be, my lord, next week. Immediately after the, whatever is there, I will placement.
Mr. B. Gowai, the learned standing counsel of the PWD department as well as the finance department submits that he did not bring the file which contains the instructions. Well, and as such, request the matter to be listed on 22nd of October 2025.
24th, my lord.
22nd, I would have had it on Friday,
Roughly.
22nd.
My lord.
26.
This recording.
Your lordship, here instruction was sought, my lord. Last, as per last week.
Two read petition, 26, 27, 28. In 22 read petition, my lord, the claim has been denied now. And in one, it has been accepted. Only that the word
We are concerned with 4093.
493,
26.
my lord, has been denied.
As per your instruction.
Yes.
Mr.
My lord, let them file affidavit. I'll
Mr.
file
I.
my
Butler,
reply. my lord.
the council appearing on behalf of
PHA.
PHE.
Yes.
PHE department submits that the amount of rupees 250,000 as well as 88,000 which the petitioner claims to be entitled to is denied. Full stop. It is the opinion of this court that the state aspect be brought on record by filing an affidavit so that the petitioner is in a position to rebut such allegations. Full stop. List this matter again on 12th of November 2025. Full stop. The affidavit be filed by 3rd of November 2025. Liberty given to the petitioner to submit file reply before the next day.
27. 4100.
27.
Here it is admitted, madam. The thing is that it says that the work was completed 3 years beyond the stipulated time, which is why, my lord, a portal for fund demand against, because it is a central funded scheme. So that portal was closed, man. Let me bring it on affidavit, man, what they want to say, man.
Mr. I. Bottakuri, appearing on behalf of the PHE department, submits that the department duly admits the amount of rupees 1,85,506 as claimed in the writ petition. However, on account of lapsing of the funds, certain requirements are to be carried out. He therefore submits that he would file an affidavit in this instant case. This is the matter on 12th of November 2025. The affidavit be filed on or before 3rd of November 2025.
28.
2116.
Here, my lord, it is denied.
Total 8,65,000. Huh?
Yes,
You're denying the entire amount.
yes, my lord.
Mr. I. Bottakuri, the learned counsel appearing on behalf of the petitioner, PHE department submits that as per his instructions, the amount of 8,95,500 as claimed by the petitioner have been denied. So it is the opinion of this court that the said aspect be brought on record by filing an affidavit by the PHA department so that the petitioner is in a position to rebut to such allegations. The affidavit be filed on or before 3rd of November 2025. Liberty given to the petitioner to file a reply thereafter. List the matter on 12th of November 2025.
Item 29 and 30.
May I please, Lordship, matter become infructuous, Lordship.
Infructuous?
Yes, Lordship. Settlement has finalized. And settlement order was issued, Lordship.
Mr.
MS Mondal.
You are there?
Yes.
In the writ petition, you have signed the wakalatnama.
Yes, Lordship.
Mr. So-and-so, the learned counsel appears on behalf of the petitioner, Ms. Enbora appears on behalf of the PNRD department. The learned counsel appearing on behalf of the petitioner submits that the writ petition has become infructuous, taking into account that the market in question have been already settled. Also, taking into account the above, the writ petition stands closed. Both the cases similar.
31 and
All right, sir.
32.
32, I pray for declaration of Lordship. Here in this case, we have reaching inspection before notice of on 23rd we have reached. So Lordship, may 10 days time may be granted to file appeal. On 23rd, our officers received the instruction.
For this matter,
Yes, ma'am. I have some urgency, my lord.
it is connected.
Yes,
This is subsequently
Yes,
filed.
subsequently filed, madam.
See, 10 days time to file appeal.
We have given you too many time. 38,
our
how much
officers
time do you
receive
require? Here,
Lordship.
make it that every time notice is issued, they will make it returnable after 1 year. Make it like that.
Otherwise, Lordship, we have received on 23rd, our officers received it. Lordship. Today we have
Mr. K. Gogoi appearing on behalf of the respondents submits that the instructions have been received and the affidavit would be filed within a week's time. List the matter on 12th of November 2025. The reply be filed on or before 3rd of November 2025. The affidavit in opposition be filed by 3rd of November 2025. Liberty given to the petitioner to file reply to advise on or before the next day.
33.
এই নতুন টুট মারি পুরানা
in this case, reply and if no opposition, reply in file, my lord. Can't be done, I'm not recently.
Yes,
We have filed affidavit, lord.
what is your affidavit stand?
Basically, his license was for one particular year. Yes, that is shop some forest land. Subsequently,
Forest land.
subsequently, you know, so coach was issued now. Subsequently, he agreed to see the IFL on top of the original place. Subsequently, but he did not. So we have issued one notice that give him 90 days time to shift his original place or some other place. But he did not. That order he has done.
So you want to go back to the original place?
We, in the affidavit, they have stated, my lord, they have conducted survey, but in that survey, we have not been called for. We are not aware of the survey, what inspection, what they have done, my lord. But we are in the same place of business from the day one of inauguration. So, my lord, in the meantime, during the pendency of this case, some development, my lord, they have offered us to convert the license from on IMFL on to off, as well as they have provided the challan for purchase of the products, my lord. And at present, my lord, this is under consideration. By October, we are depositing the fees for conversion of the license, my lord. So I will submit, my lord, let it come in the month of November, my lord.
That is, he has converted his license on to off law. That is under respect law. But he has shifted his place some other places law, which forest area law. He cannot law.
It's okay. He has only asked for stay, which I am not going to grant it now. The question, you have already filed your affidavit stating that you have issued him some so-called notice and all. Now you have given him the opportunity to have it again in that original place. Now he has therefore filed an application, given an option to go for an off license instead of the on. Now he has applied for that. So the petitioner seeks for some time without pressing for the interim break. We'll have it in the month of November. Let's see what happens. I'm not passing any interim order. I'm only granting an adjournment to him.
Yes. P62 lot. That is written by DFO. In our affidavit, P62 lot. The superintendent of excise, with reference to the subject, I would like to inform you that there are some non-forest free activity like setting up a wine shop, etc. open reserve forest areas, which cannot be allowed within the view of provision of Forest Conservation Act as well as AFR. The sensitivity of the reserve forest is.
Has he removed or not? Have you removed or not? Have you closed down the office?
No.
Same DFO, my lord, has given the clearance certificate at page number 30, my lord. Yeah, same DFO, same DFO,
130.
page 30.
What is the date of this certificate?
14 law. This is 14 law.
2014.
Yes. The latest one is, which I have been shown, is 6/9/25 law.
Same place of,
No, here this certificate is absolutely not permissible. Because of the fact that how can there be a wine shop in a reserve forest?
yeah. Actually, it is not in the reserve forest, my lord. It is in the vicinity.
If you are relying on page 30, says that this is the reserve forest land and the government may get revenue of some such IMFL on shop if open there. You are having a bar out there in a reserve forest. What else can happen? Huh? Too much.
Yes.
You close it immediately. I won't say anything. He seeks for in month of November. Take action against whatever may be. You cannot have it in the reserve forest.
Sure.
If you don't do anything, this is a case for dismissal right away. I didn't see it. I didn't have issued notice even with this reserve forest out there. There's a Supreme Court direction, categorical direction. There cannot be a non-forest activity. Is wine shop a wine, what do you call a bar, a non-forest activity, a forest activity?
Come observation law.
Then let it come on in the month of November. By this time, it will be settled because
Regarding? No, not today. You may very well show him the video. That might be enough. But otherwise, this is absolutely not tenable. First, Mr. P. Putas, appearing on behalf of the petitioner, submits that some developments are going on, and as such seeks for an accommodation. This the matter on 28th of November 2025. So taking into account that the affidavit has been filed by the respondents and the stand duly taken, this court is not inclined to pass any interim.
34.
I think that would be enough. Yes, Rana Construction. Who is that council? Rana Construction. Yes.
We have filed affidavit today.
Rana Construction person is whom?
Number 4.
Ken Chaudhary. He is now standing counsel. RM Deka. What is this matter about?
After opening of the technical.
appeals to now been disclosed to the existing public. Yes, tell me.
Lordship, we have received the affidavit from the respondents today itself, Your Lordship. It was served to us today. Therefore, we'd like to file a reply first go through the affidavit and file a reply, your lord.
There's a stay.
There's a stay, your lord. After vacation.
So we have to extend the stay.
Lordship,
28 or 27, man.
Lordship, someday after that, your lord.
I'm waiting for the estimate number 4.
What is your ground?
Lordship, our ground is that we were not given the ability to have our site inspection report, which was not given to us.
Huh?
The site inspection.
After opening of the technical bid, that too after expiry of 8 or 9 days, my lord, of the technical bid, petitioner has raised an objection that the L1 bidder has not disclosed about the new contract that has been allotted to ascertain his bid capacity. That representation was submitted after 7 days. There is a clause there. After uploading of the or opening of the technical bid, within 7 days, if anybody has any complaint, you will have to raise it within 7 days. We have received that complaint after about 8 days. Even then, we, my lord, considering the new development, my lord, we have verified it, my lord. We have found that the L1 bidder it has the bid capacity to, my lord, participate in this particular tender. Otherwise, they are in.
Finish. No interim order to be extended. No interim order to be extended. No case.
They have filed an affidavit today, my lord.
So
My lord, we have to gone through this.
you want time at time, I'm not extending the interim order. His basic question is,
Yes.
without even looking in, you question the technical competence of R4
Yes, ma'am.
L1 on the ground that he did not have the disclose the
My lord, about a new contract that has been allotted to him.
eligible.
To ascertain the bid capacity.
Qualification of
To ascertain
information,
the
my
bid
lord.
capacity.
Page 46, qualification information that was not provided.
He did not provide
The writ petition is, my lord, 5163 of
the
25.
information to be filled by the bidder in the section, and the document submitted by the physical form will be issued for the purpose of post qualification as provided for in clause 4 of the instruction. This information will not be incorporated in the contract. What is this?
This is the information regarding bid capacity, my lord.
Ah,
The existing commitments and ongoing works. So he has to disclose this, my lord. As per this, my lord.
of the ongoing work. He
Yes.
did not disclose.
No, my lord.
You had to submit the report, submit your objection within 7 days.
My,
Did you submit within 7?
my lord, that not after 7 days, my lord.
So then obviously they can do whatever they feel like. Why should this court at all look into that?
My lord, since it is apparently in violation of the SBD, my lord.
So what? You had any objection to that? It is okay. You should have put it out there. And later on, they found that it was okay. And how many bidders were there?
3 bidders.
Huh?
3 bidders.
3 bidders.
Yes.
Petitioner is there.
Petitioner is one of them.
Have you opened the financial?
Yes.
Yes,
Respondent
ma'am.
of 4 is the L1 bid.
Respondent for is L1 and I am L2, my lord.
And
Petitioner is the L.
L2.
okay. So after opening of the financial bid, you have objected.
Yes.
So then why?
Later.
My lord, kindly turn to page 63 of the additional affidavit, my lord. This provision, my lord, for corrupt and fraudulent practice. Clause 34. Additional
Page?
affidavit
60?
63. 62 it starts, my lord, 63.
Which one?
Down below B, last line, my lord.
Fraudulent
this-
practice means misrepresentation
Or omission of facts, act, or suppression of facts, or disclosure incomplete facts.
in order to influence the bidding process.
Yes, my lord.
How can it be an influence to the bidding process?
My lord, this is misrepresentation, my lord. Non-disclosing of the existing commitment. How his bid capacity will be calculated, my lord, in case of non-disclosing of the ongoing works, my lord. That is why that that clause was incorporated in the SBD. In that case, my lord, any bidder can participate, my lord, who has hundreds of works.
So if the respondent number 4 has been awarded with a contract, how does it make a difference? Means
My lord, as per the SBD, there is a requirement for disclosing the existing commitments. And in respect of 3 numbers of works, he has been evaluated as the L1 bidder. And no existing, and it is shown that at present he has no work.
where,
So in absence of this minor clause,
where is the clause?
page 47, and to that effect,
No,
my
no,
lord,
no, 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 where which are the requirements as per the condition, that is the format. The information to be filled by the bidders in section is the clause 4. Clause 4 is what? All bidders shall furnish the following information and documents with the bid in section 3. Qualification, scan copy of original bid defining the constitution of the legal, scan copy of the total monetary value of eligibility bearing and one for each of the last years, scan copy of eligibility items of regarding litigation. Yes, which one you are saying, which is the violation? Page 43?
page 47, my lord,
Page 43.
page 43, yes. Page 43.
Which one? Clause?
Clause, page 44.
Ah.
4.4.
Who meet the minimum qualifier will be qualified only if the available bid capacity is more than the total value.
And clause 4.5.
Even though the bidder made the above qualifying criteria, they are subject to be disqualified if they have made misleading or false representation in the form statement affidavit.
And
An
affidavit, they have executed
in
page
the-
48. Page 48, they have executed an affidavit.
Huh?
Page 48, my lord, there's an affidavit. The undersigned do hereby certify that all the statements made in the enclosed attachment are true and correct. That affidavit is here, my lord, at 4.5, the affidavit.
Certified that
Page 40 is
neither
the
of our
affidavit,
firms
my lord.
have abandoned any work in India nor any contract. They understand you have.
It's a part of the tender document and they have submitted this affidavit. After that, they have been evaluated as L1, my lord.
So this is subject to be disqualified. They are subject to be disqualified if they have.
Yes, my lord.
So
No, they have not disclosed, my lord. So this is not
Disclosed
among
what?
the misrepresentation. This was the existing work, my lord.
which work?
Page
Where
40.
is the requirement of disclosing the work? Tell me, show me that.
Page 47, 1.4B. Information on bid capacity. Within bracket, works for which bids have been submitted and accepted and works which are yet to be completed. Kindly turn to page 40 now, my lord.
Wait, which work? Existing commitment on work. So they did not mention about the work
Page 40 work.
40.
They issued by the same employer, my lord.
So they did not mention about this notice
my
to
lord.
proceed with the work.
So, and it was issued by the same employer, my lord, who has evaluated him as L1.
Letter of acceptance. So this they submitted when?
Before the last date of technical bid.
Huh?
They,
When did they submit?
one second. My lord, they submitted it, my lord, on, because the financial bid was open on 26th August 2025, page 37. Before that, they had submitted it, my lord.
So when was the tender notice issued?
NIT was dated 21/6/2025.
Okay. This is for short-term maintenance.
And the last date was 25/7, my lord. And the last date was 25/7, page 32.
25/7.
Yes, my lord.
So he did not submit this.
Page
particular
40, my
document.
lord.
And what is your stand, Mr. Ayer?
It was issued on 30th of April 2025, before the last date of
30th of April 2025.
page 40.
And what is this additional affidavit for?
This is for, my lord, rejecting our application, my lord.
For
The technical bid, my lord, that 5 days, 7 days notice period, my lord, they have
what is the ground? Anna construction in the light of the demand, the employers shall inform the bidder about the result of the exam by uploading on the website, giving 7 days time for objection if any from the bidder. The bidder, the employer shall finalize the evaluation bid after due consideration of objection received and intimate to the signal found to be responsible at the time and place of the bidding. Bidders who in order requested be the after the expiry of the cannot be considered. Okay, then
for bringing this before your lordship, my lord, that is why we filed this additional affidavit. And our contention is that since you are following the clause 23.5 of the RFP, then you have to follow this one also, my lord, clause 34. If they follow the 23.5,
23.5 is where?
page 60, page 60, because of clause 23.5, by relying on this clause, they rejected our applicant representation, where we brought to the notice of the employer that his bid cannot be accepted. So we brought it in a record by way of this additional affidavit, and in the additional affidavit, we have also annexed the relevant portion of the SBD, that clause 34. That lordship has just seen corrupt or fraudulent practice.
Clause 34 is where?
Page 63 of the additional affidavit.
Okay, what is your stand now?
Well, so far as our stand.
One is within 7
One is,
days.
my lord,
they did
regarding
not.
the 7 days. Other
the
than also, my lord,
second
after receiving the complaint about this, my lord, pending work which has not been disclosed by the respondent of court, we have calculated, we have shown in the affidavit also, we have calculated and we have found that he has got the bid capacity otherwise. Even if it was, had it been disclosed also, my lord, he has the bid capacity.
So your fact is, your statement is that that is only required only for the purpose of calculating the bid capacity.
Yes, whether he has got
Not
the
for the
capacity.
purpose of disclosure.
Yes.
But what does it show? Whether it is a disclosure, Mr. Dekha, what's your problem? Does your client doesn't have the money or doesn't give the money to you? Why don't you bring the entire document?
The tender.
And I'll,
Huh?
I'll bring, my lord, I'll bring.
No, what is this? You have not brought the entire document.
No,
This
I'll
is
bring.
First time this is happening with Mr. Ken Chaudhary's matters.
Yes.
This is the third time. Every matter it is there, they don't have that. Or is it that for him that whenever he comes out here, that for him, the sport is just going to look into this file like this?
I'm.
Once
I'll.
excuse, twice can be excused, but thrice can't. This is not the way how you practice, and that too from a chamber of Mr. Ken Chaudhary.
Deeply.
We impose a cost of 10,000 rupees on this. One can't gather anything because of the fact that you have not enclosed anything. Because his basic contention is this information is only required for the purpose of calculating the bit capacity. Nothing to do with misrepresentation. That be so, and therefore it amounts to a suppression of facts by you.
My lord, when that calculation was made, my lord. When that calculation was made that he meets the bid capacity. Whether it was during the before the opening of financial bid or during the evaluation of technical bid, my lord.
Did he have the bid capacity? Where is the financial document? Financial document, the technical, as regards the bid capacity, you must have prepared a chart. Mr. Gogoi.
Why not that minus of the financial bid commitment? That.
Not the minus of the technical.
Technical bid. Also you will find that page, my lord, 35.
35 of the writ petition.
My lord.
And page 37 is the financial bid evaluation. Page 36 cost three.
So how much was this the bid capacity required?
The value was, my lord, 2 crore 17 lakhs 38,850.
And what
That
was
is
the
the
bid
value.
capacity required?
Bid capacity, my lord, after calculating, my lord, when it has been pointed out by the bid petitioner, we have found that even after that work is, my lord, allotted to the private respondent 4, he has got the available bid capacity of 4073.56 lakh. That is, my lord, more than 4 crore. He has got the, my lord, capacity to execute.
But where is the condition necessary that there has to be a bid bid capacity?
Yes, my lord, that is already pointed out. The
Yes, my
11
lord.
portion has been enclosed. by-
Yes, indeed.
It is part of the.
It is part of the writ petition, my lord.
Part of the
Writ petition.
what bid petition?
Yes, my lord.
Not a part of the annexure?
Yes,
Yes, yes.
Page
Where is that?
44.
Page 44 is the
Page
calculation.
44. How much is
4.4,
required?
my lord. Bidders who meet the minimum qualification criteria will be qualified only if their
Last
available
point, my
bid
lord.
capacity is more than the total bid value. And
Will
the
be qualified only if the available bid capacity is more than the demand. The available bid capacity will be calculated as under. Available bid capacity is a maximum value of the civil engineering work executed in any 1 year during the last 3 years, so and so, into n number of years prescribed for completion of the work for which the bid is into 2.5 minus B, value escalation of 20. So this he must have met
yes, he has got the capacity to
even
even
though
execute a work of
even then if they are misleading or false misrepresentation or 20. How will 4.5 have any implication if this clause is required only for you have not enclosed the entire document at page 47.
and nothing to show, my lord, that this particular
1.4
condition is a
information
mandatory
of bid
condition.
capacity. He may not like to say many contracts. One contract also he may give.
In the instant case, my lord, he has not shown any contract, my lord. In the instant case, he has not shown any contract.
May not be, but if these are existing contracts, he
Yes.
will be showing works which have been done. He may have given.
But the page 35 and 36 does not reveal that they have verified those, my lord. The only reason is recorded.
Whether they have verified or not, we can see it from the records.
Yes,
That's
ma'am.
whether they have been verified or not.
And when they
But
verify.
what's the interim order cannot be
My
extended.
lord, when they have verified it, my lord. My lord, kindly see from the records when
No,
they have
the
verified
records
that, my lord.
Absolutely.
Because, my lord, that, because
What
by,
the main reason you have not enforced
my
the
lord,
entire
after
bill?
filing of this writ petition and that representation, by doing this, they improve their case, my lord. How it can be permissible, my lord? At the time of bid evaluation, technical bid evaluation, that exercise was never done. If it had been done, my lord, it was recorded in the technical bid evaluation committee report. It was not there here, my lord. They did it only after filing of this writ petition and by representation filed by me, my
Are
lord.
you saying that the petition, respondent number 4 did not have the bid capacity?
No, that is not.
My lord,
No, I'm asking you, Mr. Decker, kindly make it very clear. Are you saying that the respondent number 4 did not have the bid capacity?
my lord, he has not brought.
I'm asking you a simple question. Are you saying that the respondent number 4 did not have the bid capacity?
My lord, that can only be.
I'm not concerned about it. Is it your statement?
That will reveal no records.
No, no. So therefore, you want
My lord.
to make a fishing and roving inquiry out here by way of a 226.
My lord, had it been the required qualification, my lord, bid capacity, then he have to fill up this form, my lord.
Why is it required? He may not
It is a-
look into
It is a
give
part of the
that.
tender document.
No, is it required that he has to give it? He has to
As per-
place
as per-
emphasis.
as per
No,
the
no,
humble-
just for example, is it required that for the last 3 years, how many contracts he have done is he to disclose? Where is it mentioned that all existing works have to be disclosed? Where is it?
At page 47, my lord.
No. That is why I'm saying that this is a case of suppression of facts by you. You have not enclosed the entire document. Only bringing out one document from one place to the other and just showing it. This clause is at page 47 is for the purpose that once you are for the purpose of bid capacity, you can give the basis on the basis of works
My
done
lord,
as
page-
well as existing
my lord,
contracts.
At page 45, kindly be produced. Page
What is that?
45, B.
Hmm.
How the value will be calculated.
Yes.
May I? Escalation factor as specified in this section shall be used to bring the value of the level of current financial year of existing commitments and ongoing works to be completed during the next 1 year.
Yes. Mr. Counsel, are you not understanding? This is how it is be calculated. Available bid capacity. A is this into N into 2.5 minus B.
A into N into point.
This is how you calculate. So he may not give any value. Or does he require to give for the last 3 years all the bids? Did you submit all the bids? I'm asking you a simple question. For the last 3 years, did you submit all the contracts? I'm asking you. Did you submit all the contracts?
If there's a condition, my lord, then if there's a condition in the tender,
So therefore, it is not the condition of the contract that you are to only rely upon for your purpose of your bid capacity. And this could have been much better known if the entire document would have been given. Somehow this is the big problem. Only 2-3 leaflets of the tender notice and 1 word pages is being given. This is not
my
done.
lord, I may kindly be permitted to produce the SBD, my lord, entire pro SBD, my lord, on next date, my lord.
At your instance, who have not filed the entire document.
Kindly, my lord, kindly allow me.
You dismiss with cost of 10,000 rupees because it is you. If it was Mr. Chaudhary, it would have been 25. I'm not interested in extending the. Mr. Decker, this is absolutely unfortunate. Kindly convey it to Mr. K.N. Chaudhary that this is not done. He should be, being the president of the bar, he should have been more forthcoming out here and bringing all these other documents. Not in this manner. And this is the third time. It has been submitted by Mr. P. Gogoi, the learned counsel, appearing on behalf of the PWD department, that the affidavit have been filed. However, the said affidavit is not on record. To list this matter on 23rd of October 2025 at 2 p.m. Liberty given to the petitioner to file reply if so advised. The interim order he passed earlier shall continue till the next date. The respondent, PWD, is directed to bring on records is directed to produce the records on the next date. Full stop. Before parting this court, however, finds it pertinent to observe that it is unfortunate that the incident with petition has been filed by not bringing on record the entire tender documents wherein vital clauses have not been placed on record, which would have a material bearing to the disposal of the writ petition. The conduct on the part of the petitioner hence stands reprimanded. List according.
Number 4.
35.
Well, I tendered my apology, my lord. I'll bring up deeply obliged.
Do whatever you like. What is this matter for?
Same issue.
Same, 34, 35, 36. my lord.
Same. Finding all. Same ground. Okay, this statement. I place the records of.
Affidavit file,
Oh, affidavit file. Okay.
same order. In that
34,
okay, reprimand. Pre-writ petition.
37.
May it please your lordship.
Yes, what is this?
Lordship, pursuant to the last order by this honorable court, we had sought for a week's time to file the impleadment, but we were informed by the petitioners that they had not submitted the representation to the new incumbents, to the new officer. Therefore, in doing so, a representation has been submitted. We'd like some 1 week's time to file the impleadment, your lordship. We are waiting on the reply.
Okay, list this matter after the impleaded application is filed.
Much obliged.
38.
Same order. No application for impleadment filed.
No, my lord, because I could not serve copy to new incumbent, my lord.
Okay,
Only
list
the-
this matter after the impleadment application is filed.
My lord,
Yes, what is
I'm
it?
appearing on behalf of San Soikia, my lord, and Soikia, my lord. Here, my lord, the matter is pending before the arbitration at present, so the contempt may be closed, my lord. As per instruction of the senior counsel, Ms.
Where is the order passed by this court?
Page 12.
Okay. No, we close it on the ground that arbitration has now processed.
Lordship, that particular lawsuit or the lawsuit, we have complied with lawsuit, we have terminated against the termination, they came before the honorable court. Honorable court directed them to lawsuit, avail the arbitration process. And that was pending lawsuit.
That's pending, so therefore nothing remains. The present application has been filed.
After that, after compliance lawsuit, they have filed this petition lawsuit. In this.
There's another petition.
Lordship. In that petition, honorable court directed them to avail the alternative remedy law. As because lordship, the particular.
No, we are concerned with the order passed dated 2/3/2020.
He was complied with, Uti order, we have terminated the contact lawsuit. Against that, they have preferred this petition. Against that.
They have filed this petition.
This petition.
And then,
it is before the arbitration now. So
but why the contempt has been filed?
lawsuit,
Why the contempt has?
contempt they have filed the lawsuit, the earlier order was not complied with, whereas that particular order was complied with. By complying that order, we have terminated their contact. There was matter in first lawsuit, today lawsuit.
Yes, my lord.
This notice, you see, the problem with an contempt proceeding is you cannot make it infructuous.
Lordship.
It is not infructuous, I have to drop it.
Comply with it, comply.
The instant contempt application has been filed alleging willful and deliberate violation to the order dated 2/3/2022, passed in WPC number 7215/2021. It has been brought to the attention of the court that the contract with the petitioner was terminated, and pursuant thereto, an arbitration proceeding have been pursuant thereto, and the matter had been referred to an arbitration proceedings. Taking into account the above, nothing further remains in the instant contempt application for which the contempt proceedings stands dropped.
Obliged.
40.
What order violation?
My lord, order dated 8/4 of 2022, my lord. That is in page number
Huh?
14.
Page
14, my lord. 15, my lord.
43.
Page 15, my lord.
43? What
Fif-
matter you are thinking about?
Page 15, my lord.
Page
15.
interim order?
Yes, my lord.
AP Pathak, Learning Council for the Vinayak Learning in DMC and so. Mechanical check the respondent is medical apprised of the legal present status of the illegal construction of the house is and of the and the return to the petitioner. Giving interest in 15 million with regard to the Then who are you? What is the allegation?
My lord, however, my lord, during pendency of this contempt petition, my lord, the writ petition has already been disposed of, my lord.
Huh?
The writ petition has already been disposed of for non-prosecution, my lord.
Then what happened?
Well, it's dismissed, my lord.
Dismissed?
Yes, my lord, the writ petition, my lord.
Dismissed?
Yes, my lord. Because of the non-prosecution, we cannot take communication with the petitioner. However, my lord, after dismissal of the writ petition, my lord, suddenly during the vacation, he contacted us, my lord, asking the status, my lord. So thereafter again we tried to contact yesterday, my lord. He is the aged person, my lord. He asked us to sort for some time, then he will come and he's also intending to restore the writ petition, my lord.
Yes, what is your case? You are respond number 7. Okay, you want to file? Are you constructing? Now are you constructing? You're constructed. Ms. So appearing on behalf of the respondent seeks for 2 weeks' time for filing the reply. To list this matter on 7th of November 2025. Reply be submitted by 3rd of November, 6th of November 2025.
Always.
41.
Contempt method.
May I agree,
Ah.
order dated 16/11/2020
Complied?
is complied.
Mr. So appearing on behalf of the petitioner submits that the order dated 16/11/2022 passed in the petition number 6818 of 2021 have been duly complied with. Mr. N. Upadhyay appears on behalf of the contemptor. So taking into account the above, the contempt proceedings have become contempt proceedings stands dropped.
Obliged. Please, Your Lordship. Steps have been taken in respect of respondent number 2, Lordship.
Steps taken?
Lordship.
Okay. Taking into account the statement made by the learned counsel appearing on behalf of the When did you take steps
Lordship, on 10/10
of?
of this month, Lordship.
My goodness. This can't happen. Who is the person? This is a contempt or writ?
Lordship, read petition, Lordship.
What is the matter about?
Lordship, the respondent number 2 is an employee under my company. So he, after superannuation, he filed a case before the labor court for reinstatement in his job, Lordship. Then the labor court passed an order stating that the 2 months salary has to be given to the respondent number 2, which is after the age of superannuation, which is completely arbitrary, Lordship. Thereafter, we have approached this writ court, Lordship.
You're challenging for labor court's order. You gotta stay. No stay.
No stay, Lord.
Mr. So-and-so submits that the steps have been taken upon the respondent on 10/10/2025. The registry shall verify the same and list the matter upon service of notice.
Much obliged.
43.
May I please, Your Lordship? Your Lordship, as per the instruction of the petitioners, Your Lordship, like to withdraw the petition with liberty.
Your
to-
name?
RM.
Liberty Business.
RM.
What is Liberty Business. What is
RM.
Liberty? Matter filed in 2023, you want to withdraw on the second date, and now you want the liberty. For what?
After filing of this writ petition, some development was there, Your Lordship. So
Sub-development for the last 2.5 years is what?
the petitioner was not contacting with us, Your Lordship.
Then
That's
now
why.
they have contacted.
Yes, Your Lordship.
So they want to withdraw.
Yes, Your Lordship.
Okay, we withdraw it. Nothing more than. Mr. So-and-so submits. What do you say?
R.A. Mazumdar.
R.
A. Mazumdar.
R.A. Mujumdar, the learned counsel appearing on behalf of the petitioner submits that he has instructions to withdraw the incident repetition. The repetition accordingly stands closed on withdrawal. Ms. N. Bora appears on behalf of the PNR.
Obliged.
Item 44 to 48.
Why so many contempt?
Lordship, in last order, Lordship, the respondent number 8 and 9 are newly completed. And last occasion, Lordship, order.
Who is respond number 8 and 9?
Superintending Engineer, Dibrugarh Public Health Engineering, Circle, Dibrugarh. And 9 is Executive Engineer, Dibrugarh Public Health Engineering.
Where is the PWD council? Or public health council? Public health, any I, Bora and all these people? I, Bhattakur or anybody else? R.R. Gogoi. This is for non-compliance of?
Lordship, order.
Non-payment of the order.
Yes, yes, page is Lordship 15, page number 1415. It is Lordship.
Where is R.R. Gogoi? Get hold of R.R. Gogoi. No affidavit filed.
No, Lordship.
You have made the chief engineer party. All these people have changed.
Yes, Lord.
Huh?
They have transferred the previous officers, Lordship.
Wait, just wait.
Yes,
Get hold of Mr. R.R. Gogoi.
yes,
We'll take it up after some time.
obliged, please.
Or Mr. I. Bhattakur. Anybody from the
49.
Yes, what is this?
My lord, this is for non-compliance of the judgment and order 22/5/2000.
Yes, doctor. Oh, yes, what is this? Non-compliant.
Oh, they have filed an affidavit, my lord.
Yes, what is the affidavit?
My lord, the affidavit they have filed by saying that they have again constituted another committee, my lord, out of the same context.
What?
Another committee has been constituted at page 27, my lord, of their affidavit. In fact, man, out of the same, the inquiry has already been conducted, submitted the report. On the basis of the report and as per the instruction given by the respondents, this requisition has been disposed of. And instead of complying the same, they have again constituted another committee. And out of these similar issues, well, two contempt petition has been fixed on 17.
Huh?
Two contempt petition has
I
been,
remember this thing.
yes,
There's a very big matter, na?
yes, yes, my lord.
When is this fixed?
17, my lord, 17/10/2025.
17th.
Yes,
Coming Friday, my lord.
coming Friday.
We'll have it on that day, because in that case, if I remember, I directed to give us an update because they have formed the committee on 4/9.
Yes,
Yes. my
yes,
lord.
yes, my
In
lord.
that contempt also, we have filed that affidavit.
Same affidavit.
Yes, he was given the liberty to file reply if any, my lord. They have filed reply in those two contempts. Those are fixed on, my lord, coming Friday, 17th.
Okay, list this matter on Friday along with.
Along with contempt case number 98/2025. Much appreciated.
And so, obliged.
50.
Lordship, in this matter,
J.K. Goswami, yes, what is this bearing on behalf of submitted in pursuance to the direction the content have already initiated process for bringing the notice in by tender to the applicant in terms with the notice. Learned counsel hearing.
Lordship, we have given notice to the new incumbents.
You have not filed the IA.
Lordship,
Implement.
we have filed.
Implement application filed.
Yes, Lordship, but
When?
not there in the report. Today itself. Lordship.
When did you file?
Today, Lordship.
Today.
Yes.
Okay, list this matter along with the implementing application file. If you are. Implement application. Yes, what is this?
My lordship, an affidavit was directed.
Ah, wait, just before that. Take it at you. Mr. Bhattakur, you see, thing is like this. These are for non-payment of dues. Non-payment of dues, now they have made the respond number 8 and 9 recently. Service has been meted out. The only way out, if they don't appear, is this court has to issue bailable warrant, which I don't feel like doing. So better off you obtain instructions in respect to these, copies of which be given to him. None has appeared on behalf of the respondent or any of the respondents in the instant proceedings. It is seen that
Responding number to finance department has also been made a party to this. Them
in these contempts,
Yes, sir.
you are appearing.
Corresponding number. Finance has been.
None had appeared on behalf of the any of the respondents except Mr. A. Solia, who represents the respondent number. Respondent number 2. So taking into account that the instant contempt proceedings are in respect to non-compliance to the common order dated 16/11/2022 passed in various petitions, wherein the respondents were the officials of the Public Health Engineering Department of the Government of Assam. This court have requested Mr. I. Bhattakur, the learned standing counsel of the PHED, to obtain instructions as to whether the order dated 16/11/2022 passed in WPC number 7030/2021, 7071/7145/2021, 6898/2021, 6/8/79/2021 and 7049/2021 have been complied with or not. Full stop. Extra copies of the instant contempt of the present contempt applications be served upon Mr. I. Thakur during the course of the day. List this matter on 24th of November 2025 for an update. Yes, next. The name of Mr. I. Thakur be shown in the cause list as SC PhD. Yes, what is this?
My lordship, here the respondent was directed to file an affidavit, my lordship. It is with regard to the impugned order with regard to grant of
You have filed the affidavit
my lordship.
that his consideration is under 1144. So in view of that, now we can close it.
Yes, my lordship.
Where is that affidavit? When did you file the affidavit? Say.
No, I have received on 10 September. 10 September.
No. Oh, 10/9. The affidavit is not here. It has been submitted that an affidavit has been filed on behalf of the respondent pursuant to an order passed by this court on 28/2025. The registry shall place the affidavit on record and list the matter on 24th of October 2020.
52.
May I please, your lordship?
What is this?
In this case, originally the petitioner had filed a writ petition, WPC 2202 of 23.
Huh?
Petitioner had originally filed a writ petition, lordship, seeking for mutation of two two mutation cases which are not disposed of by the circle officer, lordship. And then this honorable court had given a direction to do the requisite to a circle officer within a period of 1 month. But they did not take any action. So being aggrieved, we filed a contempt petition before the honorable court, lordship. This honorable court had taken up this matter and asked for direction from the circle officer for what steps have been taken. And the respondent has filed a reply saying that they already the mutation cases have been disposed of. And basis of that report,
Has the service been complete?
Service have been complete, your lordship, and they filed a report. Again, they filed a report that the mutation have been already done in 2019, which is not the case, your lordship.
Oh no, where's the X? Okay. Applicant in your name
Yes, your lordship.
at the land covered by dock number 1259 in March by way of health. It is to be mentioned that the state correction letter was updated. The mutation case was disposed of for by correcting the land record that applicant has went by way of it is to be mentioned the same is. Then what mean?
One more dog still remains, your lordship, 1251. If your lordship may take up page number 30 of the review petition, it's clearly very evident, your lordship, that they have not given the mutation for this particular dog. Actually, there are two mutation cases. In one mutation case, there were two dogs, and they have passed the order in one dog, but they have not passed in the other dog, your lordship. And they are continuously saying that they are done it in 2019. But in 2019, there was an objection filed by the opposite, our brother. So that cannot be the case. So it has already been done on a backdated manner after the contempt has been filed. But even in that, they have not done it properly, your lordship.
Where is the original with petition direct?
Annexure 1, your lordship.
8. Annexure 1 is what?
Of the review petition, your lordship,
No, annexure J dash.
Page number 17, your lordship.
Yeah. Senate Council Iman. Senate Council Kota, from failure of the past in Iman is the thing that the past very important. Saying that both the mutation cases dated were disposed of and the records were updated. The order in contempt basis of March the hearing the part. The diet contained in executed area not sent back to the government of the need to the past order in the contract. However, the order not been able the full of no, but Mr. You file an additional affidavit bringing on record the earlier direction. You see, prior to that, in the contempt, there is another direction. Why did you file the contempt?
Contempt was filed, your lordship, because they had not taken any action based on the judgment given by the honorable court in the writ petition 2202 of 23, your lordship.
Huh?
In the original writ petition 2202/23, this honorable court had,
Where is the original direction?
that is in lordship page number 17 of the review petition, lordship. 17 review petition.
No, no, no. Now, where is the original direction? In the contempt petition, where is the original direction?
In the contempt, your lordship,
Ah,
that is page number 20, your lordship. Page number 20.
yeah. But now you see, in view of the writ petition is hereby disposed of with a directive to the response number 3 to dispose of the aforesaid mutation case number so and so file as expeditiously as possible, preferably 1 month from the date of receipt of
That is in the writ petition, lordship. The direction.
The direction was
The writ
to
petition,
dispose of both the
writ petition case.
mutation cases. They say that they have disposed of both the mutation cases.
Yes.
Now your question is, in both the mutation cases, while disposing of, they did not take into consideration DAG number 1251.
Yes, Lord.
Now, isn't this a case where you need to file an appeal against that order? You see, therefore I'm saying, you see, you came before this court initially saying that there are 2 mutation cases filed. These have not been disposed of.
Yes, originally, your lordship.
Huh?
That was the original case, your lord.
This was the original case. This court passed an order directing the authorities to dispose of the mutation cases within a period of 2 months or what?
1 month, your lordship.
1 month. Okay. Thereupon, it was not done. Pursuant thereto, you filed a contempt.
Yes.
When the matter was taken up, it was placed before this court that the mutation cases have been disposed of. The court did not, the original direction which was passed did not say that the mutation cases should be allowed or disposed of in a particular manner. It was said, dispose of the mutation cases within 1 month. Against that, you filed a contempt. While the contempt was going on, they said that we have disposed of the 2 mutation cases.
They are saying they disposed in 2019, your lordship.
Whatever may be, they have disposed of the
Yes.
2 mutation cases. Accordingly, I dropped the contempt. Okay? You filed another writ petition. Saying that look here, while disposing of all these mutation cases, what you did is that you did not decide on mutating the DAG number 1251 in my name, or you left out DAG number 1251.
It is left out, lordship.
You left out while deciding that. But the question is whether this court directed how the mutation cases are to be disposed of initially. My question is to you.
it is not been directly said, Your Lordship, but in the writ petition, the
It may have been wrongly decided.
No, Your Lordship, let me just.
Mr. Das, it may have been wrongly decided. The mutation cases may have been wrongly decided. Tag number 125951 was wrongly not decided. But it was never your case that the mutation case should be decided by this court, or to give mutation to you in DAG number 1251. No, it was never your case before this court.
Yes.
Your case was simply that you have filed these two mutation case and these two mutation case were not disposed of, for which you sought for a direction. This court directed that within 1 month you dispose. It has been disposed of, rightly or wrongly.
That is true, Your Lordship, but they did not reject the order, they did not pass any order. They
So what?
And also in Lordship, let me just.
Just for example, you make 10, you are a civil lawyer, you make 10 prayers in a suit, in a relief. You came for 10 prayers. The court grants only 3.
But others have to be rejected, Lordship. The other prayers have to be discussed and rejected. Some finding has to be given, Your Lordship.
If it is not done, then
Then in that case, it may be erroneous order, Your Lordship. I mean,
so what do you do?
go for appeal, Lordship.
Appeal.
Right.
So you therefore the remedy is appeal. 1251 has not been taken into consideration and as such this.
But Lordship, if I may just say, when in the writ petition, what had originally happened, the opposite party had approached the Honorable Court. They had filed an affidavit in opposition wherein they had totally admitted that all the DAGs, they are by way of inheritance, it is flows down to us, the petitioner, and they have no objection. So all those on
Mr.
record. Lordship.
Counsel, you are not understanding. This court cannot go into the inside. This is a high court. This is not the circle officer who is going to do the mutation. The mutation has to be done by the circle officer. You have to understand that. There's a difference between the circle officer and the high court. Are you aware of it or not?
Yes, I am.
Then,
but
or should I put a big blackboard out here and then make a drawing and explain it to you? How better way can I explain it to you? Your remedy lies in filing an appeal.
In this case, Lordship, I will pray in this
I'll
case.
dismiss your review.
Notice be issued, Lordship. Let them say.
Go
State it on
wherever
record.
I'll dismiss your review. Go wherever you like.
No, Lordship, I agree to
No,
all the findings,
but
Lordship.
Mr.
But
J. Das, the learned counsel appearing on behalf of the petitioner, none appears on behalf of the respondent. This is an application filed seeking condonation of
Lordship,
delay.
already the petitioner has gone several rounds of application, Lordship.
Absolutely, whatever may be.
And
Go.
he's 73 years old now, Your Lordship.
So what?
And they are intentionally not mutating, Your
This is
Lordship.
an application for condonation of delay of 86 days in preparing the review application, taking review of the judgment and order dated of the order dated 4/10/2024 passed in contempt case contempt C number 557/2023. Yes, this court has seen the grounds and reasons stated in the application, and the same have not been opposed. Under such circumstances, this court condones the delay. Accordingly, the IA stands disposed. Review petition. Heard Mr. J. Das, the learned counsel, appearing on behalf of the petitioner. The petitioner have sought review of the order dated 4/10/2024, passed in contempt case C, case number 557/2023, whereby this court, taking into account that instructions were placed that the mutation cases being MET/GUW/2017-18/3884/OMUT and MET/2018-19/241/OMUT have been disposed of and the records of rights have been updated, have closed the review petition. The learned counsel appearing on behalf of the review petitioner, however, submits that while disposing of the said review mutation cases bearing numbers, a number with a question, the circle officer concerned did not decide on the mutation pertaining to DAG number 1251, which was one of the prayers made in the mutation application. Pertaining to mutation case number, which one?
3884, Lord.
388 METGUW 2017-18 of the 384 of the OMUT.
Lordship, my humble submission, these two, both the DAGs are intrinsic of
take
that.
your seat.
They cannot dispose
Take your seat.
one, this Lordship.
Take your seat. This court finds it very pertinent now. Take note of that. Take note of the directions which were passed by this court in WPC number 2202/2022, on the basis of which the contempt proceedings, being contempt case number 557/2023, have been instituted. A perusal of the directions passed in the order dated 21/6/2023 in WPC number 2202/2022 reveals that there was a direction upon the circle officer, Guwahati Revenue Circle, to dispose of the mutation cases being Eduta number with expeditiously and within a period of 1 month from the date of receipt of the certified copy. It is pertinent to observe that there was no manner, there was nothing mentioned in the order dated 21/6/2023 in WPC number 2202/2022 as to how the mutation cases were to be disposed of. In the backdrop of the above, if this court duly takes note of the order dated 4/10/2024 passed in contempt case number 557/2023, it would be seen that both the mutation cases have been disposed of, and it is under such circumstances the contempt proceedings was dropped. Under such circumstances, this court does not find there being any error apparent on the face of the record or any ground for reviewing the order dated 4/10/2024. Before parting with the record, this court, however, observes that if the petitioner is aggrieved by the non-inclusion of non-mutation, not granting of the mutation in respect to a particular DAG which was the subject matter of a mutation case, the remedy lies the remedy of the petitioner lies in filing an appeal against the order of mutation and not by way of seeking a review.
Oblige, Lordship.
Raise the question. The raise the review petition. Yes, what is this? I
have for taking steps.
Huh?
For taking steps. Actually,
Why the IA has come?
I is for a 17B.
17B.
17B petition on the
That's
industrial.
for the private. That's for the private.
Private respondent, what?
Lordship,
You are the petitioner.
yes, Lord. In the IA, Lordship.
Have you filed your reply?
Lordship, we have not filed. Lordship. In fact, Lordship, I have not got a copy of the IA. Lord.
What?
I have not got a copy of the IA.
Just have
Copy
this copy.
Copy be served.
Not given.
The copy was served, you know.
Copy was given.
Lordship.
Why you are saying that you have not been
No,
given?
Lordship.
You are giving second copy to. Econ. No, यार IA second copy নাই নি IA second copy এখন থাকিব তো নে এটা copy হ'ব second copy নাথাকে নি ডিভিজন বেঞ্চত গ'লে ক'ত হ'ব ইয়াতে নোটিছ ইছ্যু কৰিছে কেনে গম সেইটো লাগিছে না It has been issued to one Dipen Sharma. Who is he?
My Lord, Deepen is my junior. The thing is this, Lordship, even if he has received it, Lordship, it's not in our file. Therefore, I have requested him to give it so that we can file an objection.
He's no longer with you.
So he is with me, my Lord. It's not, Lordship, even if he has received it, he's not remembering it.
Well,
Yes,
ask
Lord.
him to remember the signature. I hope he remembers the signature.
We may have lost it, but will kindly direct.
But he's losing on the here. You cannot do this. There's no stay. There's no stay.
Hello?
Is there a stay?
No, there is not.
There's no stay.
There is not.
And no stay.
Then how will 17B will apply?
Already LCI has been called for, my lord.
No. If the stay is not there, only see 17B.
Yeah.
No industrial dispute. We reject the stay prayer.
Stay is not necessary.
Mere filing it is no. Where in a case the labor code by its award directs reinstatement of the employment and prepares an employee against an award in the High Court, the Supreme Court shall be liable for the award in the High Court. Or the employer shall be liable to pay such workmen reviewing the pendency of the full wages when so it is not required to be stayed.
Stay is not required.
You give a copy to him. Do you have an extra copy?
Yes, sir. I can.
Give it to him. Mr.
Hey, hello.
What's your name?
PK Garudia.
Mr. PK Garudia, the learned counsel who represents the respondent. Number 3. Respondent number 1.
In this IA, I have only number 2.
Huh?
In this IA, Lordship,
No. You are respondent number 1.
respond number 1.
Respondent number 1. Have been served with a copy of the instant application. First, he submits that he would submit the reply within 2 weeks. List this matter on 7th of November 2025. The reply be filed on or before 3rd of November 2025.
Lordship, can it be 10th of November?
Okay, we have it on third. List the matter on 3rd of November 2025. Affidavit be filed by 31st of October.
Can it be on 4th of November?
No, third,
Lordship, third, my lord, I am out of.
then 7. Either 7, 7th, and file your affidavit by 3rd. A final opportunity. Also, it is pertinent to mention that on the earlier occasion, copy was duly served. However, on account of misplacing the said copy as submitted by Mr. P.K. Garodia, an additional copy have been served during the course of the day. What is this, Mr. Bhatta?
Some arithmetical mistake in the order also.
What order? What has happened?
Para number 16, Lordship.
Huh?
In the order, para number 16, Lordship.
16? Yes.
Sub-para 3, Lordship, the claimant will be entitled to the from the date of filing the claim is on the amount of risk. Instead of 23,42,000, it should be 22,37,000.
Huh?
Instead of 23,42,000,
Pair number 4.
3. 3 and 4.
The claimant would be entitled to interest at a rate of 7.5% from the date of filing of the claim petition on the amount of 23,42,000.
Lordship.
There shall be no interest on future prospect.
In Buddha para, Lordship, instead of
So you want, what is the actual amount?
31,01,000.
No. Why 23 lakhs I have arrived at?
Lordship,
You must have given it.
if
How
we
did I
deducted,
get
if-
hold of that?
if we deducted from rupees 1,01,000,
31 lakh, 1
minus-
minus 8 lakh 64.
8,64,000.
How much is it?
It comes to rupees 22,37,000.
20?
22,37,000.
Who is the other side?
No,
None of
maybe
the-
the admission stage, Lordship.
Okay.
It was this.
Therefore, this is an application file seeking correction of the order dated, judgment and order dated 2/6/2025 passed in MAC appeal number 229 of the 2025. In as much as the correction so mentioned, the correction which have been sought for is in the form of an arithmetical error while calculating the amount of compensation minus the future prospects. The amount ought to have been the total amount of compensation entitled by the claimant was rupees 31,01,000. And 8,64,000 was the future prospects, isn't it?
64. 8,64,000 was the future prospect.
Was the future prospect. And therefore, deducting the said amount from rupees 31,01,000, the amount ought to have been rupees 22,37,000 and not 23,42,000 as mentioned in paragraph 16 Roman 3 and 16 Roman 4 of the order judgment and order dated 2/6/2025. $22,37,000 instead of 23,42,000. So accordingly, the figure of rupees 23,42,000 as appearing in paragraph 16 Roman 3 and 16 Roman 4 be substituted with the amount figure amount will live figure no amount rupees 23,40,000 be substituted by the amount of rupees 22,37,000 in the said paragraph 16 Roman 3 and 16 Roman 4. Accordingly, the instant application stands allowed. Full stop. The instant order shall be a part of the judgment and order dated 2/6/2025 passed in MSC appeal number 229/2025.
We will deposit the amount within 2 week, Lordship.
That you have not done, pay interest.
55.
Not going to see it. You want, I can increase the interest amount.
Because there is conditional order.
Yes, what is this? Somebody, I for motion application for dismissal of the subsequent suit under, oh. My goodness.
I think 55.
None appears on behalf of the petition applicant on call. List the matter after 4 weeks.
56.
None appears on behalf of the applicant on call. List the matter after 4 weeks.
57.
Same.
May I please, Your Lordship?
50?
58, Your Lordship.
नहीं देखो नहीं आता. What is it?
Lordship, there are two IAs. IA 327 is for correction of the name of petitioner number 1C, Your Lordship.
In which matter? WPC number 579.
Lordship,
Where is that? What is this?
IA number 327, it is for correction of the petitioner number 1C's name, Your Lordship. While filing the substitution petitioner for the original petitioner number 1, her name was wrongly written as Pranali Talukdar Nath, whereas the name is Lordship Pranali Talukdar. I have annexed the Aadhaar card and the PAN card, Your Lordship, at page number 8.
Now, why there are two?
Lordship, the second one is for substitution of petitioner number 1D.
Thursday. Is the matter on Thursday? Service not affected by the state.
Lordship, service not affected by the state. Lordship had asked for some clarification regarding the matter. Lordship, what had happened is that we were asked to deposit a sum of 23 lakhs on the last occasion, Your Lordship. However,
Partner हो even court पे लगा है. What is wrong with it? The partner method.
On the last occasion, Lordship has heard the matter at some length.
Taking into account the matter has been shown, the matter be shown as partner. List the matter on Thursday, along with the report to be submitted by the registry as to why the matter has been not shown as partner, in spite of specific direction mentioned in paragraph number 7 in the order dated 24/9/2025. Thursday.
Tomorrow, tomorrow.
Thursday. Oh, tomorrow. Tomorrow. This Thursday মানে Friday. Friday. এইটো Friday হে আগৰটো Friday. Did you get any information on
Yes,
this?
my lord, I have received the whole voluminous information along with the reports. They have transmitted the digitized copy of the reports. If Lordship may be pleased to take this Lord, on Friday, I had some difficulty, and otherwise, my colleague will be there. Any date, my lord.
Okay, list that tomorrow. At the top of the list, giving a report as to why the matter has not been shown as partner in spite of specific directions passed in paragraph number 7 of the order dated 24/9/2020. We'll take it up tomorrow, at the first section.
Yeah, but I'm obliged.
Item 62. 62.
62.
None appears, list the matter of the 6 weeks.
63.
What is this IA for?
Sir, the Lordship has disposed of a writ petition on 6/5/2024, given of the liberty to the petitioner applicant to approach the district commissioner within 6 weeks. But due to some reason, we have not able to approach the district commissioner within that particular period. So to extend that particular period, we have filed this IA Lordship.
That service being complete.
The Lordship, we have taken the step, but due to in that office report, Lordship, due to some technical issue, that register step has not been completed, perhaps.
Taking into account that service is not complete upon the respondent numbers 11 to 42. The applicants are directed to take steps by way of speed post with 8 speed posts within 3 days from today. List the matter after completion of service.
64. Highly obliged, Lordship. The Lord Court's order dated 16/9/2025, presume that the service upon the restoration period has been completed.
Why it has come up? Service?
It is for service, my lord. 16.
Service is complete or not?
Yes, my lord. Deemed to be completed, my lord.
Huh?
Presumed, my lord, by the Lozema courts, 16/9/2025. Last paragraph, my lord. Further, it
Okay,
appears that-
service being complete, list the matter for admission. Service is complete, na?
Yes, my lord. Presumed.
List the matter for admission on 22nd.
65.
The Lordship, as per office note dated 13/10/2025, AD card received in respect of respondent T4, T5, 6, and 7.
4, 5.
4, 5, and 8.
Not
No,
received. na?
consignment report is that they are received.
Okay, service upon respondent number 4, 8, and 9 not received. It lists the matter after completion of service. This is the matter.
66.
Consignment report is.
We want to take service by way of dusty. Otherwise, your petition will begin.
Yes, I'm going to dust the.
Mr. N. Bora, the learned counsel submits that taking into account the office note dated 13/10/2025, he may be permitted to take steps by way of dusty upon the respondent number 4, 8, and 9. Taking into account the above, list this matter again on 12th of November 2025. The petitioner is given the liberty to take steps by way of dusty routed to the registry of this court and file an affidavit of service or not before the next.
Much.
66.
Service.
Service
Complete.
Lordship Dusty, and thereafter Lordship, I have submitted the affidavit on 10/10/2025.
Service complete.
Dusty upon the respondent number 4, 6, and 8.
Service complete.
Yes, ma'am.
Interim order passed, na?
Yes, Lordship.
You have, you got the records? Affidavit filed?
No, Lordship.
So sometime maybe.
Interim order passed? This is for, period for what? Settlement of
Settlement of a hard lordship.
for a year.
Yeah, lordship, for 1 year.
Ms. Enbora appearing on behalf of the PNRD submits that she is yet to obtain instruction as well as to produce the record, obtain the records. To establish this matter on 17th of November 2025 at for admission. The affidavit be filed on or before 12th of November 2025. On the next date, the records be also produced without fail. The interim order passed earlier shall continue till the next.
67.
For admission active.
Lordship, the BTC authority was asked to give instruction. BTC authority.
That service complete?
Yes, Lordship.
So we'll be needing some time since we have been appointed newly in BTC standing also. Lekib Mia has been appointed newly.
The BTC.
BTC.
So,
Sometime may be given. We've just got the appointment letter yesterday, so it has been submitted today in the registry.
you have not taken steps by the state.
No, Lordship.
The service upon this private respondent is not complete. The service upon the private respondent have not yet been effected, nor steps have been taken by way of the state. Mr. So-and-so, who appears on behalf of the PTC, submits that he requires some more time to obtain instructions. List this matter on 17th of November 2025. On which date the respondents shall bring on record the stand by filing the affidavit on or before 13th of November 2025.
তাহলে